Good morning, everyone. I'm supposed to hear good morning back. Yes. I'm Matthew Diller. I have the honor of being the Dean of Fordham Law School. Welcome to our place for those of you who are visiting with us. And it's great to see you all today. I have to say I'm still in the midst of exhilaration of the fact that we can have programs like this live back at the law school. It's the first time in 3 years, really. And now, of course, we've learned a thing or two in the past few years, and so we also can welcome a Zoom audience and a streaming audience. So it's great to be able to convene in both of these fashions. I'm here to welcome you today to the 30th Annual Symposium of Fordham Law's Intellectual Property, Media, and Entertainment Journal. And I just want to take a moment to celebrate the journal, which is one of the leading journals in the field, has published fantastic pieces by both outside authors, Fordham faculty members, and most importantly, in my mind, students over the past decades. And Fordham Law is really a major hub around issues of intellectual property, media, entertainment, information law, the whole cluster of related fields. So the journal is our flagship, and it is at the center that brings everything together. But we also have a leading fashion law institute. We have an IP institute that every year convenes one of the world's largest intellectual property conferences here at the law school in March. We have the Center for Law and Information Policy, which is one of the leading programs in information law in the country, and we have a fantastic IP clinic. And so we draw many, many students who are passionate about IP and related fields. Our student groups interested in IP, art law, and other related subjects are incredibly vibrant. We are ranked every year as one of the top law schools in the country for music law by Billboard magazine, and that's a reflection not just not just of what goes on in the building, but the incredible accomplishments of our alumni out there in the world. Today's symposium covers a really broad range of issues, but they are all incredibly important and they are all incredibly topical. So in terms of destruction of cultural heritage, it's very much in the news. It's unfortunately always in the news in one way or another, but with the conflict in Ukraine, it's really at the forefront, as well as the conflict in Armenia and other places around the world. Cultural heritage is something that sadly is always at risk, and is at risk in particular ways at this moment. The Supreme Court next week will hear argument in Warhol v. Goldsmith, a major case on transformation of works of art. We'll hear about that today. And then, of course, we've seen many headlines and much news about repatriation of art by major museums and cultural institutions around the world. Today's conference is taking place on the cusp of Columbus Day weekend, so it's a good moment to reflect on the history of colonialism and imperialism and the legacy that has brought in terms of confiscation and expropriation of cultural heritage and specific works of art. And so we're now at a moment where there's increasing accountability for that expropriation in a variety of ways, and we'll be focusing on those issues as well. I want to thank our keynote speaker, who will be joining us a little later, Irina Tarsis. And I have to say, I remember Irina well as a law student some years ago, and her passion for art law then has continued and grown. And Irina, if you're watching, congratulations on your fantastic accomplishments, and we're all eager to hear your words. The IPLJ receives tremendous support from others at Fordham Law School that I want to thank, in particular faculty moderator Leila Mindale, who will be moderating a panel later on, and who teaches our basic course in art law, as well as our great alumni who work in the field of art law. And I particularly want to thank Chris Robinson and Steve Schindler, but we have other alumni who work in the field as well, some of whom are joining us today. I want to thank Ray Dowd, who has also been a tremendous supporter of art law at Fordham Law and has also helped us secure the sponsorship of his law firm, Dunnington, Bartholomew, and Miller. And of course, most of all, I want to thank our students who put this symposium together with incredible care. To both the big picture and the details. I want to thank the symposium editor, whom you will hear from in a minute, Lily Paulson-Stevens, as well as the editor-in-chief of the journal, Ryan Purdy, and Grace Sullivan, the managing editor. I want to thank the entire symposium committee of the journal for all the work that went into putting today's program together. And now I'd like to introduce Ryan Purdy, editor-in-chief of the Fordham IPLJ. Thank you all. I wish you all the best.
Hello, everybody here and at home. I'm going to keep this as brief as possible. Dean Diller spoke to a lot of the issues we'll be discussing today, and he spoke so well that you're not going to want to hear me repeat his words. My name is Ryan Purdy, and I'm the current editor-in-chief of volume 33 of Fordham's IP Entertainment and Media Law Journal. I would like to say it is great to see all of you here today, and by all of you, I mean all of you. After 3 years, I'm getting a little tired of sort of heads in boxes on a computer screen, so this is really wonderful. I never thought I'd be this excited to speak in front of a crowded room. So thank you for making the trip and being part of today. This is the first time, as the Dean said, since 2019 that we've been able to hold this symposium in person, and we are thrilled to be able to do it. Our annual symposium is an opportunity that allows us to engage in current topics in real time. This year, our focus is on topics concerning art and cultural heritage law. Previous symposia have focused on underrepresented voices in intellectual property, copyright and free speech in the social media age, and political non-neutrality in the press. And as with those years before, we hope that our discussions today will be as timely as they are vital. For example, as the Dean mentioned, this morning's panel on Warhol v. Goldsmith addresses a case the court is hearing next week. It's the first major case on fair use in the arts in decades before the court, and one that could radically redefine the doctrine of fair use. Later, our second panel will confront the ongoing tension between national and cultural identity, memory, self-determination, and the preservation of cultural artifacts. And perhaps most crucially, as the Dean said, as Russia continues its invasion of Ukraine and we collectively grapple with the ongoing repercussions of conflicts in the Middle East and Central Asia, our keynote address and our final panel will engage with the protection of cultural heritage in times of armed conflict. We do hope that today's panelists and the dialogue they provoke adds to our understanding of these ongoing legal issues and maybe points in some directions that may lead to their resolution. Last, in closing, we would like to thank our sponsor, Dunnington, Bartholomew, and Miller. We'd also like to give a shout out to Fordham's Art Law and Media and Entertainment Law Societies for helping promote today. Thank you. And we'd also like to thank the school, faculty, our advisors, and everyone involved, our panelists for their support and contributions in getting this back in person after so long away. We are looking forward to memorializing today's symposium in a future edition of the journal that'll be printed next year, so please keep an eye out for that. And I guess in closing, I would like to introduce Lily Paulson-Stevens, who will let you know about the day ahead. Lily is our symposium editor. Her and her team have put this together, and I know she's already on my team, but she's done a great job. So please give a hand for Lily. Thank you.
Thank you, Ryan. So there's many people I'd like to thank or double down on thanks from Dean Diller and Ryan, but first some housekeeping. This is a hybrid program. About 400 people have registered to attend a live broadcast of this event via Zoom webinar. So for our remote attendees, please note that the chat and raised hand functions are disabled. Remote attendees may submit questions through the Q&A feature located at the bottom of the screen, and questions submitted through the Q&A are being monitored and may be presented by members of our in-person team. For our in-person audience, if you have a question for the panelists at the end of the panel, we kindly ask that you stand so that a mic runner can locate you and bring a microphone to you, or feel free to come to one of the 2 microphones in the center aisle here. For our attorneys seeking CLE credit for today's program, you should have received an email with a copy of the agenda, as well as links to the affidavit and evaluation forms. You can also access these forms through the QR code on the screen or outside. In order to receive CLE credit, you must fill out the affidavit and evaluation forms within 30 days of the program. And please note that you must be on time to each panel in order to get full credit. A representative from the Office of Public Programs is outside, and their emails are at the bottom of some of these slides. If you have questions, there's also somebody monitoring the Zoom if you have questions. And so last but not least, I'd like to just double down on thank yous to Ryan Purdy, our editor-in-chief, Grace Sullivan, our managing editor, and also Jamie O'Neill, our online editor, for all their support. I'd also like to thank my wonderful and dedicated Symposium committee for all of their hard work in making today happen. And a big, big thank you goes out to Morgan Bennett and Chanel Hawley from the Office of Public Programs. I'm pretty sure neither of them sleep. And last but not least, I'd like to thank our impressive participants for sharing their time and expertise with us today. In particular, our faculty and alumni moderators, panelists, and sponsors, whose support continually reminds me how exceptional the Fordham law community really is. So without further ado, please welcome our first panel, Purple Fame, Warhol v. Goldsmith and the Limits of Artistic Transformation Under Fair Use, moderated by Chris Robinson, counsel at Rodenberg Lippman Rich. And the CLE code for this panel is PFW22. Again, that's PFW22.
Good morning, everybody. My name's Chris Robinson. I am an attorney of counsel at the law firm of Rodenberg Lippman Rich here in New York, and a 2001 graduate of this law school, although not from this particular building. We were next door, and it's a great pleasure to be back here, especially in this amazing building. The United States, the first thing I would just like to do, I know that there are lots of people watching, listening to this online, but just as a show of hands, these people in the room, how many of you are students at the law school? Good number. How many of you are faculty? How many of you are practicing attorneys? Okay, great, thank you. The United States Supreme Court rarely hears copyright cases. Even more rarely does it wade into the murky waters of the scope and application of the fair use defense to copyright infringement. The last discussion on the subject was in the 1994 decision Campbell v. Acuff-Rose, which centered on the classic fair use category of parody, but which made more generalized statements about other potential fair uses that lower courts have struggled to apply over the last 28 years. And it's for that reason that the appeal to be argued before the Supreme Court next Wednesday as Andy Warhol Foundation for the Visual Arts, Inc. versus Lynn Goldsmith and Lynn Goldsmith Limited has generated such interest, even though the appeal may not turn out to be an ideal vehicle to generate the broad guidance on fair use that many would like it to be. Today, our panelists will discuss the case, the fair use issues that it raises, and what to hope for or fear from the Supreme Court's opinion. Just very briefly, I'd like to introduce the panelists. Immediately to my left is Amelia Brankoff. She's the founder of Brankoff PLLC. She's the current chair of the New York City Bar Art Law Committee, and as an adjunct professor at NYU's Steinhardt School for the Visual Arts in Law. Next along the line there is Joel Hecker. He's the principal at Law Offices of Joel Hecker Photography, Joel L. Hecker, specializes in photography and visual arts. He was an attorney for Goldsmith at the district court level and filed the original brief at that level for the district court. And then at the end, we have Philippa Loengard. She's the executive director of the Kernighan Center for Law, Media, and the Arts, and a teacher at Columbia Law School. Philippa, or Pippa as we call her, wrote and submitted an amicus brief in this case at the Supreme Court level, and she will talk about that a little bit. And it was actually filed by Nick, who's sitting right here in the audience. So many of you will be familiar with the factual outlines of this case. It's possible for the Supreme Court, but for those who are not, I'll try to set the scene. Please save your questions till the end. So, Lynn Goldsmith is a professional photographer with a high-profile career in celebrity portraiture, especially in the music world, with multiple magazine covers, over 100 record album covers, and museum exhibitions to her name. She founded the photography agency Lynn Goldsmith Limited, LGL, that licenses her works among many others. And together, Goldsmith and LGL are the respondents in this case. In 1981, Goldsmith was commissioned by Newsweek magazine to photograph the then 23-year-old musician Prince. She took photographs of him in concert and a number of portrait images. Goldsmith testified that she made specific artistic choices in those portrait photographs, with strong lighting to accentuate his bone structure and adding additional eye makeup or lip gloss. Let's show this one photograph. In the event, Newsweek published one of the concert photographs, not this one, and the portrait images remained in Goldsmith's possession unpublished. 3 years later, in 1984, Vanity Fair decided to publish a profile of Prince, whose album Purple Rain had just been released to such acclaim. Though LGL magazine licensed one of the portrait images, LGL magazine licensed one of the portrait images, this one right here, for $400 as what's called an artist's reference. In other words, a basis for an artist of the magazine's choosing to create another image for a one-time use. The magazine commissioned Andy Warhol to create that image, and the result, dubbed Purple Rain, was published on the November 1984 cover of Vanity Fair with an appropriate credit. The appropriate credit to Goldsmith, and Goldsmith herself remained apparently unaware of the licensor Warhol's cover. At about this time, though there are no details in the record as to exactly when, why, or how, Warhol created 15 related additional works, silk screens on canvas and paper, and 2 preparatory drawings for them. Assuming they were created consistent with his normal practice, Warhol or his assistants cropped the original Goldsmith photograph, reproduced it as a 2-tone image on acetate, and created a silk screen through which ink was applied with a slight shift of angle to the paper or to a canvas which had been painted with fields of bold color. These works remained unpublished and unexhibited in Warhol's studio until his death in 1987. And in 1993, the foundations set up at Warhol's death began to sell and otherwise transfer the other works in the Prince series, placing 4 in the Andy Warhol Museum in 1998. They also started licensing the images along with the other Warhol works through the Artists' Rights Society to fund their activities. In April 2016, Prince died, and the following day, Vanity Fair's parent approached Andy Warhol Foundation for a license to republish the Purple Passion, this is the one we just saw, Purple Prince, in association with a commemorative article. And on discovering that there were other works, discovering from the foundation that there were other works in the series, they settled on what is known as the Orange Prince and paid a $10,250 license fee to the foundation. This is it. Orange Prince was published in May 2016, this time without any credit to Goldsmith. Now, apparently for the first time, Goldsmith became aware of the Prince series. She registered her photograph with the Copyright Office as an unpublished work and started a negotiation with the foundation for compensation. But in April 2017, the foundation preemptively sued Goldsmith and LGL for declaratory judgment of non-infringement of the entire Prince series, not just this one, or in the alternative, for a finding of fair use. Goldsmith countersued with respect to the 2016 Orange Prince use only for reasons that the panelists will discuss and with significant consequences for the issues now before the Supreme Court. In the Southern District of New York, Judge Kotel granted the foundation's motion for summary judgment that the entire series was a fair use of the Goldsmith photograph. Judge Kotel applied the statutory for-use factors. And for those of you familiar with them, I hate to do this, but we should take a serious look at them. In the statute, it says that, notwithstanding the fact that one has certain rights, the fair use of a copyrighted work, including such use, in other words, this is not a fixed list, by reproduction or so on, for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright, and goes and then lists the 4 factors which courts are supposed to analyze in deciding whether or not something is a fair use. Number 1, the purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And number 4, the effect of the use upon the potential market for or value of the copyrighted work. Now, on the first factor, Judge Kotel adhered closely to the Supreme Court precedent in Acuff-Rose, which I'm sure we'll discuss a little bit more as we go along, and as applied by the Second Circuit in the 2013 opinion in Carrier v. Prince. In examining its purpose and character, Judge Kotel found the secondary use transformative because it has a different character, a new expression, and employs new aesthetics with creative and communicative results. It endorsed the Foundation's view that while Goldsmith described her depiction of Prince as emphasizing his, quote, vulnerability, unquote, Warhol had transferred the image aesthetically to one of an iconic character, quote, larger than life, unquote. And as in many cases, the finding of transformativeness in the first factor drove the analysis on the other 3, downplaying the protective creative elements of the photograph, emphasizing Warhol's removal of most of them, and stating that the Warhol's paintings were not a market substitute for Goldsmith's photographs and that their licensing activities were distinct. The Second Circuit rather famously reversed. For the district court, the first factor had largely determined the result, as it had in Acuff-Rose and Carrier. But the Second Circuit determined that in this case at least, the fourth factor, the market harm caused to the initial work because of the potential impact on Goldsmith's ability to license a photograph of Prince, had a significant impact on the first 3. Recognizing that Carrier had been described as, quote, the high watermark of our court's recognition of transformative works, unquote, the Second Circuit stated that to accept every use that added new expression or aesthetics as transformative would effectively write the copyright holder's creation and authorization of derivative works out of the statute. The court acknowledged the difficulty of assessing fair use cases where both works are works of visual arts, as opposed to, for example, a change in medium, but rejected the premise that a change of aesthetic treatment and artistic intent was alone enough to make the secondary use transformative. As the Second Circuit put it, the secondary work's transformative purpose and character must, at a bare minimum, comprise something more than the imposition of another artist's style on the primary work, such that the secondary work remains recognizably deriving from and retaining the essential elements of its source material. Now, in this case, the Goldsmith basis for the work remains immediately as the Second Circuit argued that the Goldsmith basis for the work remains immediately recognizable. Let's go back so we can. Remains immediately recognizable. And for the Second Circuit, the secondary work is closer to a derivative work than to a transformative one. For the second factor, the panel determined that the district court had undervalued the creative elements in Goldsmith's photograph. And for the third, the amount of the work that Warhol had taken, the Second Circuit stated that, quote, the Warhol images are instantly recognizable as depictions or images of the Goldsmith photograph itself, unquote, which strongly weighed against fair use. And on the key final factor, market harm, the Second Circuit accepted that the originals of Goldsmith's photograph and Warhol's paintings, the originals of them, occupied different markets, but stressed that the specific use of Warhol's work here had a highly detrimental effect on Goldsmith's market to license her photograph in connection to materials about Prince, and on her ability to create or license derivatives. Ultimately, the Second Circuit did not see its decision as chilling the ability of artists to draw on other works. Only that, quote, just as artists must pay for their paint, canvas, neon tubes, marble, film, or digital cameras, if they choose to incorporate the existing copyrighted expression of other artists in ways that draw their purpose and character from that work, for example, as by using a copyrighted photograph of a person to create another portrait of the same person, recognizably derived from the copyrighted portrait, so that someone seeking a portrait of that person might interchangeably use either one, they must pay for that material as well. So at this point, I'd like to bring our panelists in. And I think I would start by asking Amelia, as we've now come basically to the Supreme Court decision, or the briefing. Could you tell us a little bit now, Amelia, about what the position is that the Andy Warhol Foundation has taken in their appeal before the Supreme Court?
Sure, and thanks, Chris, for having me, and thanks to Fordham. It's so nice to be here in person with you, so thank you very much. In the Supreme Court, the Warhol Foundation is trying to get the decision overturned and saying, you know, Supreme Court, the Second Circuit is really taking a way too cramped view of what is fair use. And, you know, let's look at Campbell, which is this 1994 case, which is the most recent case, even though it's almost 30 years old, it's the most recent case that we have where the Supreme Court said anything about fair use with respect to an expressive work. So the foundation is saying, well, we just only have to look at the language of the Two Life Crew or the Campbell case, and this is totally within the language of that opinion, because this is these works are clearly transformative because there's a new meaning or message here. And this visual similarity test that the Second Circuit seems to be employing would make a lot of works not fair use that really should be, because they're saying something different. Why should it matter so much if you can still see the underlying work in the secondary work? In fact, that's an important part of a lot of creatives' process, is to use authentic underlying source material to say something new. And the problem is not only with the Warhol Foundation, you know, in this particular case, but it can have huge ramifications outside of that context, including for works that already exist and are in museums. Can the museums really show the works publicly and not be an infringement? Can collectors who own these works that use underlying source material, can they display the works? Can they sell them without that sale being an infringement? Will this chill artistic speech and expression? Because artists say, well, you know, it's too complicated, it's too hard. What if I get this wrong and I'm on the wrong side of fair use? So those are the main issues that the Warhol Foundation is bringing now.
Is on? Yeah. Joel, I wonder if you could just talk a little bit about what the Goldsmith position is on this at the Supreme Court level, and how they respond to those arguments.
Okay, well, again, I'd like to thank Chris and the university here, the law school, for having this symposium. This is also my first time out, first time in a large group. And as you can tell, for purposes of the microphone, I am doing work with my mask, which will go back on shortly. I have represented Lynn Goldsmith for over 30 years in all kinds of activities. She is one of the preeminent photographers in rock and roll and music and things like that, going way back. I represented her at the trial level, which was before Judge Kodal, with another law firm, and we set the record. That is the paper upon which the appeal was based, and which is now before the Supreme Court. We like to think that we've been vindicated, and obviously I'm somewhat biased, but correctly so, so that's the way it goes. I'd like to just respond to Amelia to start with. The foundation's argument that things go into museums and the like complicates matters is really a red herring in this situation. This is a case about licensing. Lynn Goldsmith had a stock photo agency which licenses material photographs for use. One of the people who worked for her submitted the photograph of Prince to Vanity Fair upon request. It was then used, and the Lynn Goldsmith's corporation did not find out about that until it was actually published. She did not know who the artist was going to be, and I'm not sure. The record, let me put it this way, the record is not clear because of the absence of any records of when Warhol was designated to be the artist. We just don't know. So Lynn did not know what was going on. She did know she got credit on the original use. And then when Prince died and she then saw the image, she recognized the Warhol image as based upon her work because she knows her work. Even to the extent that, I'm not sure you can see it from here, but in the photograph within Prince's eyes, you could actually see a reflection of the lights, the strobe lights that Glenn used. The strobe lights appear in Warhol's image as well. So there's really no question of that this is the one that was actually taken. We tried to resolve the case with Vanity Fair, because Vanity Fair used it. We had no idea at that point what Warhol had done. Vanity Fair said, go talk to Warhol because we licensed it from them. And eventually it wound up in litigation. But the original pieces of art are not at issue. It was an easy call because they were all disposed of way before the statute of limitations was being in effect. It was in 2003, 4, 5, 2008. So we did not have a claim on the sale or disposition of the pieces. So that was not in the case. The case is about licensing in a different market. The Second Circuit was very clear to point that out. That's a whole different issue, which should not get reached by the Supreme Court because it was not briefed and it was not part of the case before. So having said that, you deal with the licensing. And let me just add, for the litigators out here and potential litigators, one of the rules we first learn is you sue everybody who might be involved, because you shouldn't make the decision of guilt or innocence or liability or not. We did not go after Vanity Fair because presumptively Vanity Fair has an indemnification from the foundation which licensed this. We have a standstill agreement in place, which is on the record with Vanity Fair, which means the statute of limitations has been told until the eventual final outcome of the case, which may not be the Supreme Court decision, because even if it's upheld, it will still go back for damages. But in any event, the action against Vanity Fair still remains alive and will be pursued, assuming that there's not a complete reversal or dismissal.
Thank you. Pippa, you're obviously perfectly welcome to chime in on any of that at all, but you filed an amicus brief in this, which spoke about many things, but in particular focused on the detrimental effect on the professional photography industry if the Andy Warhol's arguments were to be successful. In other words, if that this is really about licensing and that the Supreme Court should sort of really focus on licensing, and in this particular case, because the base image is a photograph, it's particularly troubling. Do you want to sort of talk a little bit more about your brief and about the arguments you made in it?
Sure. And I'm going to be a repetitive record, but I also want to thank Fordham for having us, and especially Lily, who's been just wonderful and helpful throughout the process. And I want to thank my fellow panelists who really are the best of the best. I'm going to pick up on what Joel was saying about licensing, because this is a case about a market that is not only viable, but essential to photographers. And I come from a family of photographers, and so I felt very strongly about this. The licensing market is how photographers of all kinds make a large portion of their income, okay? Especially, as I'm sure you know, in the digital realm, photographers have faced an uphill battle in protecting their copyrights. Works can be copied so easily and transmitted so effectively across the world. This is a situation where there is a set market, a set license market set up. And all you have to do is look at the roster of amici to see things like the Graphic Artists Guild, the Digital Media Licensing Association. I mean, you can't get more set than that in terms of evidence of having a strong marketing group for photographers, and ASMP, of course. And so it is important that we keep that market alive, because without it, we have a real risk of jeopardizing photography as a viable career. So Lynn Goldsmith is incredibly successful, and so it's clear that this can happen to anyone. This isn't just someone who wouldn't have had the resources to sue, but there's plenty of photographers out there who wouldn't. But her niche, as Joel said, certainly not her exclusive area of work, but she definitely has a reputation in photography of musicians. The way that Ms. Goldsmith and her peers work is that they license their works to others. They can sell them, they can license them, but licensing obviously is a longer stream, a longer existing stream. And while certainly you can make prints of your photographs, obviously the more prints you make, the less value they get. And therefore we're gonna have, we need to have that licensing stream where the photographer retains the image and can license it. And there's a concern among photographers that without that licensing stream, the viability of taking pictures at all, the equipment that's needed at this point for a professional photographer is so expensive. The time that goes into planning an image and setting up a photo shoot and developing or printing the work, depending on how they're using, what film they're using, or if they're using digital. And all of that still takes so much time that without any hope of economic success, they really have less ability to pursue their passion and their talents. So that's, I think, the concern among photographers.
So while it may be that the case should be just about licensing, it's quite clear from some of the other amici that have filed briefs, and on behalf of museums, on behalf of artists themselves, and on behalf in either neutral or in support of the foundation's position, that there is a real concern that the Supreme Court will have more to say than will just impact licensing. And that, for example, if you're dealing with, how do you deal with the issue of orphaned works? If you are an artist who appropriates work and incorporates it into your work, if licensing is the key to all of this, how is an artist supposed to be able to find out where they license something from? Who is the authority to give them that? Who does it belong to? And orphan works has always been a major problem in the copyright world. So I think there is this sense that it goes a little bit beyond that. I mean, how do you answer that?
Well, I first of all think we should note that of the 26 amici who filed, and of the ones that were neutral, I don't think that there are any neutral briefs that were actually in favor of Goldsmith. People file, oh, I'm sorry, in favor of Warhol. Sorry. That was not good. Yeah, so in fact, the number of amici who were supporting I just can't go with Warhol was quite slim. And also anyone can file an amicus brief. And so I'm not discounting any of the talented and many of my friends, lawyers who wrote the briefs on behalf of some of the organizations you mentioned, but it doesn't mean that the issue is really present before the court. But I think orphan works are always a problem. But I don't think it's fair to say because there are some works that we cannot find the author of, and I'd also like, or copyright holder of, I'd also like to say that the amount of diligence that goes into searching for the owner of the copyright in an orphan work can vary greatly. I don't think it's fair to say because of this potential issue, everyone gets a free ride. It's, you know, you can make tons of comparisons to other situations where allowing everybody to go free because it might be hard to prosecute one or two or find the owner of one or two. It doesn't work.
If I can just follow up on that, I also think it's a red herring, and you'll hear that from me quite often, because an orphan work, by definition, means you don't know who the author is or can't find the author. The Wall Foundation wants to define transformative as conveying a different meaning or message. How do you know what the original meaning or message was when you don't know what the author is doing or what the author said? You can't locate the author. So I'm not sure, aside from the problems that Pippa mentioned, how you would address the orphan works within the fair use argument here. It just doesn't seem to apply, especially when you're dealing with licensing. Because if you're dealing with licensing, somebody is the licensor. Somebody is giving permission to do that. So you basically don't have orphan works being licensed, except in certain situations, like the Betterman organization, which you may or may not have heard of, which takes all kinds of old images and licenses them, with the caveat that they don't represent that they have permission from the original author, and you as a licensee go out and find it. But most of their work predates 1922 and 1935 or stuff like that. But generally speaking, there's a difference between licensing in this situation, where you know who the licensor is, and one where you just don't know and can't determine perhaps what the meaning or message was from the original.
I mean, if I could just add something, I know you asked about orphan works, but it's sort of in this context, we're talking as if the license, the person who would be granting the license is going to be reasonable, going to be available, going to have good intentions, going to, you know, have a price quote that's going to be, you know, feasible. But so that's a part of it. But another part of it is, well, what if they just say no? I mean, what if you really have something, you want to say something, a new meaning, new message, you want to use somebody's underlying work and they just say no? What happens then?
Well,
Right.
we look at that by going to the statute, which clearly says the copyright owner has the right to say no. You can't use my work. If it's unpublished, the author has a right to determine whether it's to be published or not to be published. And that's Supreme Court decisions going way back.
Right, but I guess what I'm saying is if you're coming into a context where you know, copyright and fair use is a really hard area to counsel clients on, because it's not like an area where you can look at a statute and say with certainty, 100% certainty, this is the law. No, you can do this. Yes, you can't do this. There are shades of gray in this area, I find. And so, you know, you're acting, well, you don't feel like you need the license, right? But you want to just make sure everything's buttoned up. You don't want to necessarily rely on fair use. So you ask, and then they say no, and then that creates a whole nother situation, because then, you know, you can rely on fair use, right? But then you've got a situation where the person knows that you're interested in using it, you get a no, and then you use it anyways, and then they're going to say, oh, well, that's willful infringement.
Yeah,
So that's a reason to have, you know, that's a counter argument of why we need a robust fair use.
yeah, and I think just to follow up just on that a little bit, I mean, what does it say about the state of fair use, that there is this intense desire for greater clarity, and that there are many who would like the Supreme Court to come up with something that applies to more than just a licensing situation, to give some real clarity to the transformative, the first factor of the fair use analysis, that will be of some guidance to people who are, like practicing attorneys, trying to guide artists and others on what they can do without coming afoul of the law. So what does it say about the state of fair use, that there's this yearning for a case which actually helps with pinning that stuff down?
It just helped rephrase your question. The Warhol Foundation, in its appeal to the Supreme Court, did not address the fourth factor, which is the licensing. It just addressed the first one, transformative. So as much as the fourth factor is very important, and to some courts the most important factor, the Supreme Court is being asked to deal with the first transformative factor.
I would say, Chris, that Congress had the ability to create a bright line, and I know that many of you have heard, oh, I can use 6 seconds without paying. I can use 1/10 of a work without paying. And we all seek, especially as attorneys, bright line rules. It makes us sleep better at night. But Congress purposefully dodged that and created a test, an amorphous test. And going back, courts have always, pre-1978, put in a fair use test that was a factor-based test. Congress didn't make this up out of whole cloth. And I think it's for a reason. It is almost impossible. I challenge you all to go home tonight and spend the next 36 straight hours trying to come up with a way that you could codify fair use in a way that was fair to authors of original works and of secondary works. I think that if we all worked on it for every hour of the day between now and next year's conference, we would be no further. It is an almost impossible thing to do because there are so many different variables. Okay, so we're looking for guidance here from the court. I would say that it's unfortunate that this case is the one before the court. It is not the best test case that we could have. And so it's possible that we get some codification that's not great, some bright line that falls too far one way or the other. I think bright lines are bad in this situation.
Mm-hmm. Okay, I think there are many that would agree that one of the greatest fears of this is that the Supreme Court is going to try to do too much and try to say too much to cover not only this issue with licensing, but also, and not only the issue where you've got just a comparison of two works of art, two visual works of art, but something that's going to implicate copyright, fair use and copyright across all different media, which of course gets very tricky and different when you're talking about books, or if you're talking about movies, or if you're talking about computer code or whatever. So I think that is a real concern, that the thing is narrowly tailored enough that it answers the questions and gives some clarity, but that doesn't get so broad that it's inapplicable to other situations. I wanted to ask a little bit about this issue of intent. When the Copyright Office looks at a work for copyrightability, it will not take into account what the artist's intent was in creating the work. When you look at substantial similarity in infringement context, you're supposed to put the two works side by side and have an ordinary observer look at them and say, well, are they substantially similar? You're not really going any deeper than what you're looking at. But in this case, fair use, you're looking at the purpose and character of the second work. So at this point, then the intent of the second work does become relevant. And this is an issue which I think has been debated backwards and forwards between the parties in this. What is, do you think, panelists, the actual real role of the intent, the artistic intent of the secondary user in a case such as this when they argue for fair use?
First of all, a large part of my brief is saying that meaning and message is not the same as purpose and character. And I think that that's a key takeaway. But I would also argue that purpose and character is not intent. There's not intent in the statute. And I'd like to say that what is intent, right? I think that one of the hardest things about fair use is you can go down rabbit holes of, okay, you should look at artist intent. Okay, what intent? Their intent in the market, their intent in the creation, their intent in what actually was created. Intent is a loaded word.
You can, that is shown very clearly when you have a movie or an art show or anything similar, which is then publicized, and you have 5 or 6 critics, one hating, one loving, one saying this means this, what means that. And I recall a situation which may be atypical and may be true or not, but where these critics put all kinds of meaning and wonders into this art show, which was done by a 6-year-old child who obviously had no intent whatsoever except to put some paint on a piece of paper.
Well, you don't know that, Joel. Did you do a psychological analysis?
That's the point.
I mean, I think it's an interesting question. I mean, I come from this and thinking of, you know, like the Supreme Court in the Google versus Oracle case made a veiled reference to what a lot of people think is a Warhol work, right? When they say you can use an advertising logo and use it just as is and have a different and transform it and make it a fair use, right? So then you have some artwork that I think is identical. You know, you can have a fair use case where you have an advertising image of, I don't know, the Marlboro Man or something. And then that you turn that into a Richard Prince work, right? And that's shown in the Guggenheim. There's absolutely no changes. Maybe the change is the title of the work and putting it in a frame, right? But there's something different that's going on. And so is that the artistic intent? Is that the purpose and character? But that is something that's totally relevant to the analysis, is what you're doing with the work. And if you're saying
I would also
something
say, I
different.
mean, if you look at the statute again, the statute, when you look at the enumerated categories, for purposes of criticism, comment, news reporting, teaching, scholarship, research, it's sort of almost impossible to figure out what those are unless you look at the intent of the user, right? How can you figure out that something is a parody unless you can figure out that that's what they intended it to be? Same thing with criticism. How can you look at the secondary work and justify it as criticism unless you can identify that what they're doing is criticizing? So perhaps when you're talking about other uses that are not enumerated, such as an artist using another artist's work, you do perhaps look at their intent, what they were trying to do. And whether you look at what they are actually trying to do or whether you look at what a reasonable observer might think they were trying to do is another possible question.
I don't think that either parody or criticism is that difficult. Put it this way, if you can't tell it's a parody, it's not a parody.
Let me just throw one thing in that isn't really in the legal papers at this point, but the references to the Marilyn Monroe by Warhol and the Marlboro Man and the rest, those images were never challenged. They came out, they were painted. Marlboro was not about to sue when it got all that publicity. Campbell's Soup was not about to sue for copyright infringement when they got all that publicity. So no one knows whether those would have been deemed to be infringements or fair use at that time. We just assume it's fair use because it was never challenged, but it was not challenged.
And some were, and Warhol licensed. When Warhol was challenged, he got licenses.
Oh, that's, I think, an important part, and that's in the briefs. Warhol infringed on a number of pieces. He got sued, he settled, he stopped using other people's work and began to either license it or take his own photographs from which he used as reference material. And none of the print series surfaced at all during Warhol's lifetime. It was only after he died that the Warhol Foundation began to license the works. So all this comes into play when you perhaps would determine the meaning or message or anything like that. because the argument certainly has been made that Warhol just didn't assume he had the right to do this.
What if we ask a different question? I mean, so Judge Kodal decided that they were transformative and that Warhol was saying something different, right? And then the Second Circuit reversed that and said, as a matter of law, it's not. But what about just having it be a jury issue?
Well, this goes into the whole who determines meaning and message, which is one of my major problems with the meaning and message test. And in my brief, note that there's really no party that could be the best interpreter of meaning and message. And yeah, we could turn it to a jury. I think a lot of artists would be upset if 12 of people who might never have been in a gallery or never seen an art show determined what their meaning and message was. You know,
I think they might be even worse, the worst position if they got 12 art critics on a jury.
fair enough.
I mean, what do you panelists think about the fact that, excuse me, the factor of the sort of David and Goliath factor here, that you know, you're dealing with a photographer who in this case is an important photographer, I would agree, but you know, compared to Andy Warhol, who's a major well-known artist in terms of their market, in terms of their public perception, and in other cases in the past, you know, the Blanche v. Koons I'm thinking of, where you're dealing with or the Carrier case, where you're dealing with a big imbalance in public perception between the two users. To what extent do you think that affects the fair use analysis, or should not affect the fair use analysis? And I think it was referred to as, how did they refer to in one of it? Anyway, so what you sort of think of as a celebrity privilege, so to speak?
Well, we argued before Judge Kodal that this is not a case of its fair use under the four factors except Warhol. And we got the impression, and it's clearly in the opinion, that a Warhol is recognizable as a Warhol on its face, and therefore it's fair use for Warhol to do anything that came out with somebody saying that's a Warhol. Obviously, the Second Circuit disagreed, but we put in our brief that there is no such exception in the Copyright Act except for Warhol.
I think it's telling and unfortunate. It would not be how I would lawyer, but everyone obviously has a different style, that in their reply brief, the Warhol Foundation basically mocks Lynn Goldsmith's challenge and says that obviously he describes Andy Warhol as a universally recognized creative genius. And then there's a photographer. I think that is an unfortunate path to go down. Because you don't want to set up, as in Prince and Carrier, the idea of someone who sells at Brooklyn galleries or Manhattan gallery, Manhattan galleries in Prince versus Carrier with Beyonce and Jay-Z in attendance versus the poor schlep person under the Brooklyn Bridge with her studio. Which at this point is probably more expensive than the Upper East Side Gallery with Beyonce.
But to be fair, I mean, it's not totally irrelevant to the analysis, and the Second Circuit has said as much in the Carrier case. I mean, there are different markets, particularly for the original works, and that has to be relevant in the analysis when you're looking at the fourth factor.
Well, but that depends upon what the fourth factor is. In this case, it's licensing. It's not original work. It's not somebody buying an original Warhol for $5 million or $100 million, as opposed to Lynn Goldsmith licensing something for $1,000 or $2,000, or even the Warhol Foundation licensing it for $10,000. They are different markets, and that's what the Carrier case was. But in this case, as it comes down now, it is not a market for the originals. And each of the courts so far, with the district court, the Second Circuit, and then the Second Circuit revised opinion, of all distinguished this by saying they are not dealing with the originals. That is not what's an issue here.
Right. Just before we open this up to your questions, I'd like to ask the panelists, and I'd be interested to hear views of others in the audience as well. And it's a sort of I guess it's a sort of tricky question, as Pippa told me. But to what extent do you think that the present ideological makeup of the Supreme Court is going to come into play here? Is it in any way going to color the result? What are those interests that might do that? There was an interesting article today in ArtNet News on the government submission of a brief and the larger implications of a licensing decision here on the internet. And I think that I'd be interested to see whether you think that this newly activist court would have anything to say about copyright.
Well, the only thing that I can go by is the recent computer code decision, which was a very, very narrow determination of fair use in a very particular situation. And the court clearly said it doesn't go beyond the facts of that case. We were somewhat surprised that the Supreme Court took this case on certiorari after such a short period of time of the Google case. But I'm not sure right, left, blue, yeah, red, or any of that factors into copyright. I'm not sure how that would happen, but we've been surprised before.
The only thing I would say is that the Google opinion was written by a justice who's no longer on the bench. And it will be interesting to see if that makes a difference. I've heard that some justices are very keen on protecting individual property rights. In that case, I think it leans towards Goldsmith. But this could be tea leaves that were spilled on the floor. And, what do I know?
Yeah, I mean, it's hard to say. I mean, we haven't had, as I said, a Supreme Court case in almost 30 years. And I think the only judge that's still on the bench is Clarence Thomas. And so it's a totally different, but that was a unanimous, if my memory serves correctly. And he was in support of, what I think is the language that the Warhol Foundation is, grasping. So,
right.
Yeah.
So I'd like to open this up to your questions, if you have questions. I imagine we have mics here in the front here, if you'd like to got any questions or comments for us.
Don't ask for comments.
Hi, my question is specifically for Ms. Brankov. So I noticed your point about the museum display of artworks and what the implications for museums would be for fair use. And I actually thought of the note I'm writing this semester has to do with appropriations of work on social media and the fair use implications of that moving forward. There was a recent article written by an attorney that says, justices stand to clarify social media fair use in Warhol case. Have you heard people's different takes on that over the course of this entire case moving forward to the Supreme Court? And if so, I'd like to hear your opinions on it.
You mean on the use in social media?
Mm-hmm. In terms of companies taking down under the Digital Millennium Copyright Act, people's artworks based on other people reposting them on social media, and saying that it infringes on the artist's copyright. And there's been litigation about it as well, with photographers litigating against their work being posted without any sort of licensing, when really there's almost kind of this imbalance between your average social media poster who can't possibly license an artwork, but maybe wants to parody it in some sort of way, or critique or comment it.
I mean, it's an interesting question. I mean, there's certainly a lot of meme culture going on, right? And in that context, I think there should be a broad fair use. I'm not familiar with the article that you're mentioning, but I'd be happy to chat with you after.
Let me see if I can step in on that, because I think your premise is faulty to a certain extent. Clearly, there are many situations like that, but in my experience, and I deal a lot with this, the use on social media is fleeting. It's a fan club. It's whatever it is. We send out cease and desist letters. That entity disappears. Maybe damages are worth a few $100s. And so it is a real issue on behalf of the copyright owner to try to police this and go after these infringers. Sometimes we succeed and they take it down. It's really a conundrum because the honest user will respond and we can settle it in an amicable way. It's the fraudulent or intentionally, someone who infringes, whether intentionally or not, but knowingly does it, who won't respond, and either a jurisdictional issue is raised because they're in a different state and it's impossible to follow up. We send cease and desist letters, takedown notices, which are effective, but they're expensive. And I don't think it's really from the position you're going from. If you look at it from the other avenue, how do you enforce this against hundreds and hundreds of uses? And just one other point, once it's up on one blog or one social media, and then it's copied 50 or 100 times, you have to go after all 50 or 100 entities to get it down. So it's not quite as easy as the concept that you're thinking of. So maybe you can enlarge your paper a little bit.
Of course, it's definitely a work in progress, and thank you both for your comments and clarifications. Thank you all for attending our symposium today. It's been really interesting listening to you guys speak. I do have a question with regard to the potential implications of a reversal on, on derivative works, and where to draw the line between fair use and derivative works when an overly, liberal standard kind of risks crowding out that statutory protection. So I was wondering if you guys could speak a little bit on that.
I think that is a key point, and it's addressed in most of the amici. I think that this half of the room should work on drafting fair use. I think this half of the room can look at how you just draw the line between a transformative use and a derivative work. I think that it is very clear in a lot of areas other than visual arts, right? In movies and books and things like that. I think visual arts is unfortunately the sticky wicket in this. And where is that, right? I'll be darned if I know. I would not want to be the congressional aid tasked with coming up with a rule there, or clerk trying to figure out where that should be. I don't think there's an answer, is my quick answer.
I don't think there can be an answer because there's such a difference. For example, one of my clients does documentaries to appear on HBO and things like that, full of photographs. So when we analyze those photographs where we cannot get a license, most of them we can, but sometimes you can't. So what do? We look at the size based upon other opinions, how long it's on screen, how important is it, what is it used in relation to, what is it telling the audience, and things like that. And then you come to a decision, and you hope no one sues. But that's important, because what you tell your clients is anybody has a right to sue, whether right or wrong. So you can't say, I can't be sued, because all you can do is get, and what does happen, attorney's fees because it's a frivolous lawsuit. And that is a powerful weapon.
I think it's interesting that you bring up that you're considering the sort of the intent of the authors in that particular work that you're considering to use, and you spoke a lot about intent earlier, and I guess I have a follow-up question. What is your thoughts on the proposition that judges should not be art critics, and how does that play into the first prong of transformativeness? And how do you kind of draw that line? I mean, especially you were talking about the difference between juries and judges, but if a judge is more well-versed in the law, how do you then separate the two?
Well, let me just take a quick crack. I forget the judge's name from New Jersey Supreme Court, who was talking about pornography. I can't define it, but I know it when I see it. I'm not sure you can get a better definition than that for clarity, but I forget, whatever it is, you really can't answer that question with any degree of certainty because people have different views.
Judges are no better than juries. There's just a jury of one.
The only thing I would say is that because it's the Copyright Act, these cases all come before the district courts, and the district court judges, for the most part, are really smart people. No, not supposed to appellate court judges, but maybe traditionally district court judges are, I don't know. At least they're specialized in dealing with copyright issues, so they may have had more opportunities to think and talk about these things, and hopefully they have a balanced opinion on this thing. It's a fundamental problem, again, just so you have the dividing line between what is a derivative work and what is transformative. So I think our time is up, unfortunately. It's been a lot of fun. Thank you very much. And there we go.
Our second panel is Out of Context, Reframing and Repatriating Objects in Museums and Public Spaces. The CLE code for this panel is OCR22. Again, that's OCR22. It's my pleasure to introduce our moderator, Stephen Schindler, founding partner of Schindler, Cohen, and Hochman.
Thank you, Lily. Good morning, everyone, and thank you to Fordham Law School for having us here. It's always nice to be back, a proud alum of Fordham Law School of some many years ago. So I was in Madrid last week giving a talk on the US legal efforts over the years to restitute Nazi-looted art to the heirs of its original owners. This journey, particularly post-1998 Washington principles, has been one of both cooperation and resistance, melding legal and ethical considerations for our museums and museums abroad. And while I was there, I had a meeting with the General Counsel of the Prado, which, as some of you may know, has in recent days been wrestling with the restitution of art taken by the Franco government during the Spanish Civil War. And here and abroad, museums have started to interrogate their own collections of art and objects, particularly those taken by colonial powers, deciding how best to balance their fiduciary and ethical obligations. So with us this morning to discuss these issues are three practitioners and scholars who will help us examine this state of affairs. I'll briefly introduce the three panelists in the order in which they will speak, and you can find more about them in the bios with the materials that you have. So first up is Rudyard W. Cirrus, who's a partner in Freeborn and Peters LLP and an adjunct professor here at Fordham Law School. He is duly qualified in the UK and New York, and his practice is concentrated in Caribbean and sub-Saharan African regimes. Next is Nick O'Donnell, who is a partner in the litigation department of Sullivan and Worcester and the leader of its art and museum law practice group. He has litigated some of the most important restitution cases in the US and is the author of A Tragic Fate, Law and Ethics in the Battle Over Nazi-Looted Art, which I highly recommend. And then finally, we have Erin L. Thompson, who holds both a PhD in classical art history and a JD. She's an associate professor of art crime at John Jay College, where she studies the damage done to cultural heritage and communities through looting and the deliberate destruction of art. She's the author of two books that I know of, Possession, The Curious History of Private Collectors, and Smashing Statues, The Rise and Fall of American Monuments. So now I'm going to turn the program over to Rudyard.
Okay. Good morning, folks. Good morning. Firstly, I would like to thank Lily Paulson-Stevens, Dean Miller, Ryan Purdy, for inviting me to today's 30th Annual Fordham Intellectual Property, Media, and Entertainment Law Journal Symposium. I'd also like to thank my former partners at Dunnington who actually sponsored this particular program as well and asked me to participate. Now, my fellow panelists, the moderator, ladies and gentlemen. My name is Rudy Series, and I'm delighted to be here. This is the first time I'm actually speaking at this particular symposium. And as was mentioned earlier on, I'm actually an adjunct professor as well here. So this is also my first semester. So I'm delighted that Fordham has taken me under their wing, as they say. I'm a UK and US qualified lawyer. And my involvement, and interest in all things sub-Saharan African and the Caribbean goes back to my representation of the South African government, in the United States and Canada, going back to 1997, and my familial ties respectively. However, my focus on the restitution issue, as it relates particularly to the sub-Saharan African region, only dates back a few years. And that learning curve has been steep, challenging, and also invigorating at the same time. Now, today's discussion is entitled Out of Context, Reframing and Repatriating Objects in Museums and Public Spaces. So not just because it's in the title, but context is everything. In my humble opinion, in order to address this issue and truly assess the strengths and/or seriousness of the conversations that are taking place today in museums all over Europe, the United Kingdom, and also the United States, we have to provide some historical context. This is not a new discussion. It may appear that the genesis of the current conversation has coincided with the movements such as the Black Lives Matters and its progeny. However, while such events may be a factor, this has been a live issue all the way back to, for example, in the case of the Benin Kingdom, the original taking in 1897, when the king, Overamwem, forgive me if I'm not pronouncing that correctly, was dethroned by British forces during the Benin Exhibition, as it was called. Later, the Year of Africa was considered to be 1960. Why? Because at that time, 17 colonies belonging to Belgium, France, and the United Kingdom gained independence. The conversation on restitution continued to gather pace at that point. Now, these newly independent countries were creating their own newly formed national identities, and there was a desire to advocate merely against a Western understanding or analysis of the universalism of art. Later, in the hallowed halls of the United Nations General Assembly, in October 1973, Mobutu Sese Seko, the then president of Zaire, raised the issue of restitution in his speech to the delegates. It is at this point that 0 hour in the worldwide restitution debate was considered. Now, a quote from his speech, which is contained in Benedict Savoy's book, The Africa's Struggles for Its Art, reads this way. It states, during the colonial period, we suffered not only from colonialism, slavery, economic exploitation, but also from the barbarous, systemic pillaging of all of our works of art. And we are therefore poor, not only economically, but culturally. Those works of art are to be found in the museums of rich countries, are not our primary commodities, but in fact, the finished products of our ancestors. Those works which were acquired for nothing have increased in value so much that none of our countries has the material means to recover them. That was the Zairean president 50 years ago. That speech could clearly be utilized today again. Similarly, in his book, The Brutish Museums, Dan Hicks lists 17 officers, or as he calls them, looters, from the records and pictures available from that Benin expedition, which were actually compiled by the looters themselves. Hicks gives examples of the items that were actually taken by the individual officers. I'll give you an example. A chap called William Alexander Crawford Coburn, who was born in 1863 of the Niger Coast Protectorate Force, sold 69 Benin objects to the British Museum in 1897. Paid for through the Christie Fund, which included wooden arrows, embossed brass discs, a ceremonial war jacket of wool and hide, bracelets, hip masks, armlets, a carved wooden box and lid mounted in brass, a dagger, a sword, and, quote, an altar of the hand. So there you have, in one instance, all the different items that one individual who participated in the Benin exhibition has listed as their things that they acquired, some of which they then sold directly to the British Museum. By the way, in case you didn't know, Dan Hicks himself is the curator of the Pitts Rivers Museum, which is the private museum of the University of Oxford, which also received and maintained several artifacts from this Benin expedition. Now, over the past 100 years or more, the UK and EU, now I have to separate those two things because in today's world, the UK is no longer part of the European Union, of which I'm extremely disappointed. Moving on, over the past 100 years or more, the UK and EU museums have used multiple reasons, okay, for not providing restitution or even loans of African artifacts. The reasons for which, over the years, have shifted to the current situation, depending on what that current situation is. And so in some situations, they have indicated, quote, the items were lawfully obtained. Not sure about that. They have actually indicated that if they were to provide loans to these countries, they were concerned that these items would not be returned. Why? Because they believe that the country to whom these actual items are loaned, to whom it probably belongs in the first place, might not actually return them, okay? The suggestion also is that some of these countries wouldn't know how to take care of these items. They wouldn't know how to store them, how to maintain them, okay? So they were better off in, quote unquote, the West, okay, in these museums because they're available for the benefit of everyone. Okay, so you have this classic universal museum sort of conversation. Further still, in the United Kingdom, the Charities Act actually prevents museums from breaking up collections, even if they wanted to. So their hands are tied. Sorry. So the historical context, okay, therefore has been one of deny, delay, and at all costs, don't return. So where are we in the conversation today? Right now, we are deeply divided. We have those that believe that restitution and repatriation is a moral and legal imperative. Conversely, we have the critics of restitution that believe allowing restitution is akin to opening a Pandora's box. And if you do so, that could lead to the, quote, emptying of European museums. Now, however, in spite of that negative view expressed by some of the critics, we are still seeing today restitution takes place. For example, in the last few months alone, we've seen 26 pieces looted after the war between the French and the King of Dahomey being returned. The King of Dahomey the Kingdom of Dahomey was formerly a kingdom in the south of modern-day Benin. And that particular war took place in 1892. The pieces themselves, including a carved wooden royal door, royal thrones and statues, have been on display in French museums since 1900. And by the way, President Macron back in 2018, announced that the return of these items would take place. Yet it has taken 4 years and the passing of new law in France to make it legal to return the artifacts, which were seen in France legally as properties of the French state. Now, the University of Cambridge, in September of this year, returned the Benin bronze as well, which was looted by the British in 1897. They returned that particular piece to Nigeria. In August of this year, the Horniman Museum and Gardens handed over 72 pieces, including several Benin bronzes, to the Nigerian government. And then also in July of this year, the German government agreed to return 2 Benin bronzes to Nigeria as well, and they even signed a political agreement which could lead to the return of hundreds of other pieces. So it would seem that the tide is actually moving the direction of returning items to their countries of origin. Again, though, context is everything. By some accounts, it is suggested that over 10,000 pieces or more were taken, quote unquote, looted, only in the Benin city sacking alone in 1897. So the fact that we have a few pieces being returned might not be seen as actually moving the needle. Dan Hicks, in his book, has posited that there is probably 70,000 pieces in museums around Europe and the United Kingdom which haven't even been catalogued yet. They haven't even recorded what they have. They're sat in boxes in the basement of these universities. I presented on this issue of restitution, to the African Union Consuls General in April of this year. And one of the consuls general from a North African country raised a very important issue. He said, in most instances, unlike the sacking in the Benin Kingdom, records were not kept. So in this situation, where you have not the Benin scenario, countries have had the items stolen, but no records at all were kept of what was stolen. So if restitution is denied and delayed, even where you have pictures and records of the looted items, including where some of these items are even being housed today, we know where they're being housed. How on earth do we start to actually address the issue of repatriation, where we don't even know what is yet to be catalogued or properly recorded? Thank you very much.
Thank you, Rudyard. Nick, you're up next.
Thank you, Steve. Thank you, everyone, for organizing this and bringing us together. It's really great to be here. I can't claim the privilege of having attended Fordham Law, but I did go to a Jesuit law school a little further north, so I feel slightly kindred spirit. It's great to be together. How do I start my?
Children and technology.
I'll get started. Hopefully we can get these slides going later. What do museums do? Really, how much have you thought about it? In considering today's panel, I found myself stuck for a bit on that question, because to consider the question of reframing or repatriation, whether from the perspective of the law or something else, it is hard to come up with a good answer without first grappling with the before. Reframe what? Repatriate from where? I won't philosophize at you for too long, but I think it's important to have that in the background as we talk about what museums can or ought to do. The history of our topic here, repatriation, is still largely yet to be written, but there are some useful precedents and laws that may start to give us a sense of where things may go from here. It's a bit of a generalization, but certainly the vast majority of what is in museums in the United States today are the product of philanthropy in the last 150 years or so. From the greatest of the classic museums like the Met to single artist museums like the Nicholas Roerich Museum up Broadway, which I encourage you to visit, that I've had the privilege to advise, someone usually gave the money or the art or both. These are typically private charitable foundations or corporations run by arts professionals, their boards of directors consisting of other professionals and benefactors. They are subject to the laws of property, nonprofit governance and tax law, and import and export controls. Elsewhere, overseas, museums are far more often state institutions, themselves often a product of a confusing mix of patronage, conquest, and gift, and subject to overlapping regimes of export control, whether based on national origin or not, and cultural property protection that can make the sale or removal restricted or even prohibited. So back to my first question. Just last month, ICOM met in Prague and has approved a definition of museums as follows. A museum is a not-for-profit permanent institution in the service of society that researches, collects, conserves, interprets, and exhibits tangible and intangible heritage. Open to the public, accessible and inclusive, museums foster diversity and sustainability. They operate and communicate ethically, professionally, and with the participation of the communities, offering varied experiences for education, employment, reflection, and knowledge sharing. Okay, but this is a legal symposium, so I'm going to throw some law at you. What might cause a museum to entertain or be compelled to repatriate an object? One of the most salient remains customs laws. Something is brought into the United States, quote, contrary to law, as indicated in 19 USA Section 1595A, which is in the slide somewhere. The federal government has the authority to seize it, and the importer may forfeit it, bearing a burden of only probable cause. The government bears the burden only of probable cause to seize it. This has been invoked with various degrees of success in various disputes over cultural property involving museums. Quite famously, of course, Portrait of Wally was a dispute about ownership arising out of the Nazi persecution of its owner, Leah Bondi, but the legal case was about customs laws. Sure, we have a picture.
Take a short moment here while we're trying to straighten out the slides. For those of you watching remotely, it may seem a little puzzling, but here we go.
So this is the ICOM definition, which I read to you. This is the customs laws. The key is, well, I'll get to the key. It's about the import. So this is the Portrait of Wally. The legal case was about customs laws, specifically when it was imported for exhibition here at the Museum of Modern Art. The issue was whether the Leopold Foundation and its founder, Dr. Leopold, knew it to be stolen property. Judge and later U.S. Attorney General Michael Mukasey ruled that that question was one of fact, a dispute that had to be resolved at trial. The parties settled before that trial took place. Similarly, and surprisingly, given that the Wally case turned on the fact that the painting had not acquired, or the museums had not petitioned for immunity from seizure under the Immunity from Seizure Act before importing it, the Pinacoteca de Brera loaned, wrong order, this painting by Girolamo Romano, Christ Carrying the Cross Dragged by a Rogue, to the Mary Brogan Museum of Art in Tallahassee in 2011. The Department of Homeland Security seized it in response to claims by the heirs of a French Jew, Giuseppe Gentili, from whom it was seized in Vichy, France. The museum chose not to contest the seizure, and the painting was returned to the heirs. Turning to older examples, at least as to the artifact, the St. Louis Museum of Art successfully rebuffed efforts by DHS and the United States to seize this, the mask of Khan Nefer, from the museum. The St. Louis Museum purchased the mask from Phoenix Fine Art in Geneva in 1998. The United States argued that the mask was stolen before it was brought into the country and also invoked the National Stolen Property Act. Egyptian records indicated that the mask was excavated in 1952 and placed in museum storage in 1966. Yet only in 1973 did anyone notice it was missing. The US and Egypt in the background argued that it could not have been exported legally, but the district court ruled that the US hadn't made the allegation specifically enough, and somewhat surprisingly, the United States missed its deadline to amend the complaint to add more details, and that was that. Finally, in recent years, DHS has been active in objects concerning Middle East origin. In 2021, government seized the so-called Gilgamesh tablet from its display at the Museum of the Bible in Washington, alleging that in 2003, a U.S. antiquities dealer had purchased it from the family member of a London coin dealer. It was alleged further that in 2007, the antiques dealer sold the tablet with a false provenance letter stating that the tablet had been inside a box of miscellaneous ancient bronze fragments purchased in a 1981 auction. This false letter traveled with the tablet, as it was sold several times in different countries, eventually sold in 2014 to Hobby Lobby, which conveyed or displayed it at the Museum of the Bible. When the tablet was seized, the Justice Department put out a statement saying that Hobby Lobby had consented to the tablet's forfeiture based on, quote, the tablet's illegal importations into the United States in 2003 and 2014, and the tablet was returned to Iraq. So that's kind of government involvement. Increasingly, this is the DOJ statement, increasingly, and I don't have a lot to add, but of course here in New York, the district attorney has been extremely active in seizing objects both in the commercial markets and at museums, using his authority, in the criminal context. In addition, countries overseas have started to act essentially as private litigants or private market participants, depending on who you ask or how you characterize it, in an effort to repatriate objects. This case involving Christie's in the Republic of Turkey, which Steve's partner Tom Klein, representing Christie's and Michael Steinhardt, involved the Turkey's claim that the so-called Stargazer figurine had been exported illegally under Turkish cultural property law. Turkey pointed to a 1906 law that declared anything from Turkey to be Turkish cultural property, which could not be exported without government permission. And Turkey argued that based on its resurfacing in the market in 1966 or 1963, I forget which, it could only have come out of Turkey without the requisite permission. And the district court disagreed and said essentially the gap in information didn't answer the question of when in the first 3,500 years of its existence it was excavated and left the territory of what is now Turkey. And increasingly important to a lot of these cultural property disputes, the district court also held that Turkey had waited too long and was barred by the defense of laches from asserting the claim now. Similarly, or in the kind of market context, Sotheby's was involved in a dispute with Greece over a bronze horse figurine from the geometric period. Like Turkey, Greece has an act that says, quote, all antiquities, movable or immovable, found in Greece and in any state land, in rivers, lakes, and at the bottom of the sea, and in municipal, monasterial, and private estates from ancient times onwards are the property of the state. This object came to auction at Sotheby's. Greece requested that the figurine be withdrawn, and I think in any sort of colloquial sense, asserted ownership over it and said to Sotheby's and to the consignor, you should not sell this. This is Greek property. Sotheby's and the consignor, I guess Sotheby's didn't join the suit, but the consignor sued Greece, arguing that Greece had injected itself into the commerce of the United States and thus was not immune from suit. Now, sovereign immunity is a whole topic we could spend a day on, which I won't. It's the subject of other cultural property disputes, including ones I've been involved in, as to whether one of the exceptions to sovereign immunity in the statute apply. Many, including my case 2 years ago in the Supreme Court, invoked the expropriation exception. In this case, the plaintiff invoked the commercial property exception, which is the most often successful exception that's invoked, which is that when a sovereign state acts like a private actor in the commercial market rather than a sovereign state, it is not immune from suit. So famously, the Argentine bond cases, for example, had lots of ramifications, but ultimately, if you come to the United States, issue commercial paper on a common market, you are not acting like a sovereign state, you are acting like a commercial issuer, and you can be sued. This was the argument that by coming to the auction house in the United States and saying, you shouldn't sell that, I own it, they are acting as you or I could. If I see my stolen property for auction, I can intervene and say, don't sell it. But the district court disagreed, and the Second Circuit upheld that, saying that the letter by Greece claiming ownership was, quote, inextricably bound up with sovereign activity, not a commercial activity subject to exception. So where does that leave us in the current moment? To me, there's no question that the conversation has progressed more rapidly than most could have imagined. And Rudy, I enjoyed your remarks, and I'm certainly looking forward to Aaron's too. But taking a step back, I do think it's fair to say that many Americans' museums now are still struggling to keep pace with the topic. Here too, I see a parallel in the past and to a lot of the things I've worked on. 35 years ago, the idea of a major set of disputes centering on the theft and forced sale of art during the Nazi regime was regarded by most as an area of academic interest, if that. My thesis has always been that the combination of new information, dogged advocacy, and an eventual shift in the commercial market of where the market's interests were headed led to what can only be described as a seismic shift. As an example, this painting by Van Gogh, which is, I won't butcher the title in French, but it's the view of the asylum in Saint-Remy, where he spent some time, was consigned in 1990 by none other than Liz Taylor for auction at Sotheby's. It did not sell, but that is not why I bring it up. I bring it up for another thing that didn't happen. Nobody apparently noticed in 1990 what this painting's past was. In fact, a German Jewish woman named Margarete Mautner left this painting behind when she fled Germany in 1939. Happily, she survived. Liz Taylor acquired it at auction in 1963 and owned it, had it until this 1990 consignment. I think the point is this: had that 1990 consignment taken place today, it most certainly would have been flagged for further scrutiny and likely a conversation with Mautner's heirs. Instead, it didn't sell, was withdrawn from sale, and when Liz Taylor consigned it again in the early 2000s, the Mautner heirs sued, and the district court in California effectively concluded that the consignment in 1990 put them on constructive notice of the painting's whereabouts, such that the claim was time-barred. But I bring this up because the future of this discourse is sitting right here and on the Zoom call. People rightly point to the publication of The Rape of Europa, or The Lost Museum, in the early 90s as a paradigm shift in awareness and understanding of the issue of Nazi-looted art. Without that scholarship, does Congress focus on Holocaust expropriated bank accounts and insurance policies in the mid-90s? Without that congressional action, does the State Department convene the Washington Conference on Holocaust-era assets? And without the Washington Conference, is there anything analogous to the Washington Conference principles on Nazi-confiscated art? I would suggest the answer is no. A similar moment is underway, and Rudy referred to some of these examples. In 2018, Felvina Czar and Benedict Savoy published their report, The Restitution of African Cultural Heritage Toward a New Relational Ethics. It addressed the fraught relationship between the museum collections and what had been the colonial powers of Europe, and the places from which many of these objects came. Do not dismiss popular culture either. Just before the Czar-Savoy report came out, the movie Black Panther was released. Clearly imagined by Marvel Studios as a filler between the last two Avengers installments, the movie was a true phenomenon. The moment I sat up in the theater and began to realize that something remarkable was on screen was when Michael B. Jordan, his character, visits the Museum of Great Britain, and as the curator lingers to condescend to him, he says calmly, "How do you think your ancestors got these? You think they paid a fair price?" I certainly don't condone what he does after that, but a moment had begun. And what was first dismissed as almost a curiosity, the Czar-Savoy report has affected policy across Europe from France to Germany. Soon, worldwide attention focused on the so-called Benin bronzes. These include, most famously, the bronze plaques seen here, but also carved elephant tusks and ivory leopard statues and wooden heads. They come from the ancient kingdom of Benin, now in southern Nigeria. On February 1897, James Phillips, a British official, destroyed Benin City in a violent raid, a self-described punitive expedition. These artifacts are now all over the world, many on display since just a few months after their removal in 1897. So why now? Thanks to scholarship, again from SAR, but also from Dan Hicks in Oxford, whom we heard about, fresh attention fell upon these collections. Museums from Boston to Berlin have agreed to repatriate them, some have not. These ideas are powerful and museums are affected. Indeed, the very idea of certain kinds of museums suddenly seems shakier than ever imagined. When I spent a formative period in Berlin in the mid-1990s, I tried to visit almost every museum in the city, which was no small task. At the time, the Ethnologisches Museum was in the western suburb district of Dahlem, a quiet neighborhood graced with a sprawling mid-century modern complex that housed artifacts from around the world. As part of more recent ongoing reorganization since the Cold War, the Stiftung Preußischer Kulturbesitz, the Prussian Cultural Heritage Foundation, that oversees the city's museums, came to the idea of the so-called Humboldt Forum on the site of the old Stadtschloss, the Palace of the Hohenzollerns, and designed to resemble it, as though the pre-World War II military monarchy was what we needed to honor. In the blink of an eye, the idea went from a curiosity to a dinosaur, an outdated idea that was the answer to a question no one was asking. And while the museum is now open, awkward and largely devoid of coherent message, and I will disclose my own ongoing disputes with the SBK, who was the counterparty in the Supreme Court case, the SBK deserves praise for its uncharacteristically swift response to the Benin bronze controversy. This August, the SBK signed an agreement with the Nigerian National Commission for Museums and Monuments to return 512 objects taken in the 1897 expedition, with others to remain in Berlin for now on extended loan. There are legal principles at work here, and the examples I gave may prove what people try. And the assertions of ownership, natural cultural property, and the propriety of export all play a role. The Charities Act that Rudy mentioned seems recently to have been amended, and it's going to be interesting to see how that plays out in the United Kingdom. There are also important contextual questions to go back to where I began. What is a particular museum? Why is this particular museum there? As you monitor this issue, however, I would encourage you to be expansive in your thinking. Those rules of decision alone did not hold sway. Had Nigeria sued the SPK in Germany, it would likely have failed. Had others tried to initiate French legal proceedings, the collections there now under Senate directive to be returned might not be. This is not, to be clear, to suggest or to undermine or minimize the assertion of legal rights. We all know how few ownership disputes are resolved by final judgment on the merits, but whatever your perspective is on what should happen to these objects, the legal journey can be just as important as the destination. Thank you.
Thank you, Nick. And now Aaron will, I think we're going to move our focus to another part of the world.
So almost comically perfectly timed to go along with the closing thoughts there, that the law rarely actually plays a role in repatriation claims. I have somewhat provocatively titled my talk that cultural heritage law does not exist. Obviously, this is not literally true, as your excellent presentation laid out, but I'm trying to make the point that it might as well not exist because so many disputes, both successful repatriation claims and rebuffed repatriation claims, happen without any reference to the law or even the regulations American museums have set up to restrict their own activities. And this is especially true of this growing field of repatriation requests for looted, sacred, and art stolen during colonial times. So what I'm going to do is give a series of short interlocking case studies to make a point about what actually matters in recent repatriation cases, which is frustrating when the law does not operate as it should, I think, but can be freeing for activists to realize these are the things that actually matter rather than, say, the UNESCO Convention. I want to emphasize that I have played a very small role, mostly as documenter in these cases, and the organizations that should get a lot of credit, and I encourage you to follow them on social media, are the Nepal Heritage Recovery Campaign, of which I serve as an advisor, and an anonymous activist known as Lost Arts of Nepal, who all the time is matching archival photographs like this one to objects on display in museums around the world. So I want to talk to you first about this statue. It's a co-joined deity, half male, half female, Lakshmi Narayan, who's an avatar of Vishnu. It was stolen from a shrine in the Kathmandu Valley in 1984, and shortly thereafter published in this book by the artist and scholar Lin Sinj Bangdel. So pretty known in Nepal that this was stolen. Nepal banned the export of cultural sacred antiquities like this one since 1956. And it's not as though it could have been sold legally anyways. This was a deity. It was worshipped it was not really owned, it was cared for by the community around it. And these sort of statues, if they are broken, if they have to be removed from active worship, are ritually disposed of. So there's absolutely no legal or moral story to justify it being out of the country. This object disappeared until it briefly resurfaced in another 1990 sale at Sotheby's. A Nepali journalist and activist named Kanak Mani Dixit spotted this listing only after it was sold and could not trace it further. So it remained lost until an American artist named Joy Lynn Davis began a series of paintings sort of artistically repatriating stolen objects to their surroundings. So she took a bunch of photographs of the shrine from which it had been stolen and painted the Lakshmi Narayan back in gold. She would also occasionally, while working on this series of paintings, do Google searches for Nepali objects in American museums. And because she had been staring at the source photographs so intensely for the months it took to do this painting, she was able to recognize this object in the blurry background of a photograph taken by a blogger at the Dallas Museum of Art, where it turns out it was on long-term loan, a promised gift from a collector named David Owsley. We'll get into that. So she didn't know what to do. The Nepali activists didn't really know what to do. They sort of sat on this information for a couple of years until I heard her give a talk about it. And I said, let's try and do something about this. That doesn't really seem right. So I wrote an article about it in Hyperallergic, which ultimately resulted in enough action, enough public outcry in the US that the Dallas Museum surrendered the object to the Nepali government. And last December, I had the privilege of going to Nepal to see it reinstalled back in the shrine it was stolen from. So this is the very first reinstallation back into worship of a repatriated object in Nepal, and has led to, even since then, a few more. So this is the real idea behind Nepal's current activism, not just to move it from one museum gallery to another, but to put it back into worship. You can see in this slide, the bigger one is the original, that it was replaced with a replica for worship, a version, not an exact replica. And so now the newer Lakshmi Narayan had to move over, and they're both sharing the shrine, and they're both getting worshipped. One just moving detail of the many I could tell you about this whole story is here you see Kanak Mani Dixit, the journalist who had been for decades trying to find this piece, inspecting copper ornaments made in the 18th century to put onto this statue during special festival days, and had been kept by the guardians of the shrine even after the theft of the original. So thinking they would never get to use them again, but they were able to put them back on during the ceremony. Just last week, a picture of the ceremony appeared on John Oliver's segment on Last Week Tonight about museum ethics. And let me tell you, real career highlight when you get a call from a producer of John Oliver and you say, I got just the story you can have him talk about. So that's very, very satisfying, and is a signal of a changing public opinion about these objects. But it's also, to me, this was a happy story, did not involve the law. The museum did request the involvement of the FBI Art Crime Squad, but in a way that really had very little to do with any of the legalities of when it was stolen and et cetera. Seemed more to me like a delay technique to tell the donor that they were doing the best to protect all his other donations, because this man, David Owsley, lives in New York, is the major donor of the Asian Arts Collection of the Dallas Museum of Art. Here they are celebrating him in their catalog. They started their South and Southeast Asian collection with donations from him. Then he donated so much they persuaded him to donate cash to build new galleries for their collections. And just to show you as an example of some of the other objects with questionable provenance that he has donated or promised to donate are a series of objects from Cambodia, which you might know is currently reclaiming a lot of its stolen artifacts. So definitely they're gonna have to make a stop in Dallas to look at these objects. Even more disturbingly to me, I found out is that he's the major benefactor of a museum at Ball State University that renamed itself after him because of the thousands and thousands of donated artworks, including hundreds and hundreds of antiquities that he gave to the museum. Gave to this sort of seemingly random university museum because his grandparents not only founded the museum, they founded the university. He's from the Ball family, you might recognize, have drank a cocktail recently out of a Ball mason jar. So they made a lot of money in that, and other industries gave the land to the state to start Ball State University, and both built and filled the museum and absolutely continues to fill it. He plans to bequeath, as of this 2011 article, millions of dollars to the museum in his estate, as well as his remaining artwork. So you can see how a museum would be reluctant to alienate a donor by asking questions, too many inconvenient questions about provenance. And indeed, they praiseworthily had their collections records open to the public online, so I was able to see just how little provenance they had required from him when accepting donations of objects like these from Mali and Iraq, heavily looted areas for antiquities. There are indications of disturbing origins. So here are groups of objects that probably came from the same grave in Mali, whose archaeological heritage has been heavily looted. And so to an archaeologist, I look at this and think this is a sign of a desecrated grave. It's not acceptable to me to have this in a museum without at least asking questions about where it came from. And indeed, it's not just me. Museums, including the Ball State University Museum, should be obliged to follow the ethical guidelines promulgated by their professional organizations, including the AAM, the American Association of Museums, of which this museum is a member, which say that if you're going to acquire this type of material without sufficient ownership history, you need to be transparent about your justification, which they simply are not. So I thought, well, let's get into the bigger problem here. A colleague of mine and I did and just published, which I've included in your CELE materials, a survey of museums who are obligated under the AAM, but not the AAMD, to see how many are following their acquisition guidelines for antiquities. And the long story short is none of them. Even the easiest one of having a publicly available acquisition document is not, in the vast majority of cases, followed. So I encourage you to read that. So these are examples for all of these documents of where the regulations, where the laws exist, but just aren't followed for obvious reasons of museum time and expertise being limited, and for donor relations. If you're going to get all of your money from someone, you don't want to poke that gift horse. And just one final story, I thought I'd have another happy ending to close out. So it's a little bit confusing. These are photographs from different angles and different eras. On the far left is a photograph of a carved wooden roof strut from the 9th century of a yakshi or a salambanjika standing on this sort of grotesque figure. Second from left is the top of this roof strut, which appeared at the Metropolitan Museum, was donated to them. In the middle, you have the bottom part of it, still remaining in this monastery in Kathmandu, the Itimbahal monastery. And then over here on the right, the head of the steering committee of the monastery pointing to where it was stolen from in the 1970s. So I visited to go to the party, right? The Lakshmi Narayan party, but also little stop at Itimbahal, and took a series of photos, which I tweeted, like Yakshi goes here, Metropolitan Museum. I just want to point out that I have apparently an extensive collection of 80s paisley blouses. That's a different one. I sent the measurements to the Metropolitan Museum to say, just in case you didn't know, this was here. And the curators wrote back to me to say, oh, well, we've known about this since 2016 and we're working on it. And permit me to be a little skeptical. Again, it's a two-piece puzzle, not something you would think should take 5 years plus to work on figuring out. It's documented in situ. They have preserved the remains of it. They, by the way, they were like, do you want to hold it for the photo? I was like, oh, no. I don't want like self-proclaimed repatriation activist drops 9th century sculpture. So, but what I did do instead of holding it is I wrote an article for Foreign Policy pointing out the sort of ridiculousness of this delay. And lo and behold, although I'm sure the museum will tell you it had nothing to do with that, they sent it back. So suddenly, without any legal involvement or authorities' involvement, the bad publicity of having this delay resulted in a repatriation. And here are some of the members of the Nepal Heritage Repatriation Campaign getting back not one, but 2 objects from the Metropolitan Museum. So I encourage us to think, when we're thinking about the law, also about all the other factors that go into shaping repatriation campaigns, both the making and the receiving of them. Thank you.
So I have some questions, but I realize we've gone a little over the time that we had budgeted. So I want to just go to audience questions first, because I think we only have about 5 more minutes. And if we don't have questions from the audience, then I'll sort of pick up. But I think I see some. Go ahead, ma'am.
Hi, thank you everyone for speaking. So as a provenance researcher at a New York museum and a law student, I'm often struck by how often the fields talk past each other and make assumptions about the work that the others do. So I'm just curious what you would like to see materialize when, museum institutions and lawyers who are committed to restitution and creating new equitable restitution practices, how best to bridge those different levels of expertise in these projects. Thanks.
I just want to say to that I realize the reality that provenance research takes so much fun, so much time. There's no flipping a switch and then it's automatically available. I often take a very critical stance because I am sometimes told by museum employees that is helpful in persuading, the budgeting to get more provenance research, et cetera. So I don't think there's some magical solution. I would want to see just more of it. Ball State University had their provenance records publicly available online. After I wrote an article about it, they removed that public access. So that is an example of what I don't want to see. But yeah, more cooperative realization that the museum can be richer for having this information, even if an object shifts elsewhere.
I think to the point you started with, the talking past each other, I think it's a matter of understanding each other. I got into this whole nonsense because I had researched the provenance of a collection in the 90s pursuant to the AAMD's task force report. And I am somebody who has always maintained it's not that hard to understand the principles that work on either side. So if you are a provenance researcher, and I have been surprised in some of the disputes I've handled as a lawyer when I'm taking someone's deposition at this sort of lack of baseline familiarity with certain concepts of time, place, coercion, as I like to put it. And likewise, I think lawyers need to understand the same way we need to understand anything to do with our experts, the kind of work that goes into it, the kind of uncertainty that is implicit in the hard cases. But I think everyone could stand to be in better dialogue.
From my perspective, the only thing I'd say is common sense. I mean, look, there are so many times that we know through documentary evidence from photographs, etc., that these items didn't just suddenly turn up, in a university or a museum, And so I think that if you're able to utilize a little bit of common sense first, that will help us to actually get where we need to get to. Beyond that, provenance and the research that goes into it is extremely taxing and extremely complicated. And I get that, but I think that we can deal with the low-hanging fruit first.
Go ahead. Sir in the back.
I wanted to reference another gatekeeper of sorts, the IRS Art Appraisal Panel. I was wondering if you've all run into either cases yourselves or case law where if for, let's say, settling it for a trust or something, or decedent's estate, if the provenance can't be proved, then does it go to the DOJ, or where do they fall into place with the art appraisal panel, if they do?
I mean, my general understanding and experience is the IRS will value it at the maximum level that's defensible, and the IRS will value contraband or stolen property as though it were not, and say essentially that's your problem in another context. I don't know of any cases where the IRS came to that conclusion, but also tried to refer elsewhere than the federal government. But maybe someone else does.
Yeah, my law school note was proposing that the IRS should value unprovenance antiquities at zero for tax deduction purposes, which obviously no one has paid attention to. But no, they are not really. They don't care about provenance.
Well, and famously, this was sorry, I didn't mean to cut you off, but the subject of the Rauschenberg Canyon dispute several years ago, which could not be sold because it included bald eagle and migratory bird feathers in violation of federal law. It was the object was by definition contraband, but it was a Rauschenberg collage. And so the estate said, it's worthless, we can't sell it. And the IRS said, oh, no, it's worth $30 million. And that case ultimately settled, but that was their starting position.
I think even though the panel is not supposed to know whether they're valuing it for gift tax purposes or for estate tax purposes, they seem to figure it out. Because the appraisals are often very high for estate tax purposes and very low gift tax purposes. That's been my experience. We're almost out of time. Is there another question? Quick question? Go ahead, sir. And then we'll get to one more in the back.
How far back in time are we legally entitled to go? A seizure committed in the late 19th century is relatively recent. Napoleon seized artworks from around his empire, and many of those then returned after Waterloo. But Wellington was acting on the basis of a counter-conquest. Right? What is the time limit? How far back can we go?
Well, I mean, courts have been very skeptical of going back very far. I mean, just to impose the legal framework on it, which is part of why, to Aaron's point, of the need or the importance of other factors. But, you know, what has come up a lot, which I referenced a few examples, but there are many others, are the laws, at least of the 19th and early 20th century, in some places reference the restriction on things coming out of those places. But a lot of these objects, by any definition, are not subject to that kind of law. So if push comes to shove in a legal dispute, the answer to your question is probably not very far back at all.
Thank you.
And one last question from the, ma'am, did you want to ask a question?
I had actually the similar question because I'm a Russian lawyer, but I'm originally from West Africa. So actually this topic was really interesting for me. I'm from the country of Benin, not the kingdom of Benin. That was the Dahomey. So I had the similar question because of course a lot of artifacts, a lot of, like our own famous king's throne is in France right now. Even when I was a kid, I would go to the museum and I'll see replica. Original is in the Museum of Paris and something like that, or a replica, almost everything. And I'll ask my parents, like, why we have a replica if it's our king, and it's his palace. So my question is, but not all of it was like stolen or taken during the colonization. Some of that was sold by the corrupted government during, this changing of government. So how hard is it? It is to return something, or have you worked on cases when it was actually sold, but it was not supposed to sold? Because say, for example, if the corrupted president or whoever is in the government signed that contract, but it was not his property, he was not supposed to do it. So how hard is it to return? And have you ever met such cases? Have you worked on it?
I mean, I haven't worked on cases like that because, again, I think that there are so many things right now that are clearly items that were taken in certain expeditions or punitive expeditions, as they were called back in the day, But clearly, okay, you know, if there is an argument that a previous government actually, you know, illegally sold a national treasure, you know, that's something that has to be dealt with internally before you can then make a decision of whether the country goes after it. And just the issue of sovereign immunity issues as well. You know, a lot of these cases, you know, you're not going to have litigation because the countries aren't going to subject themselves to litigation as a government. And so you're going to have some entity that is going to be appointed effectively to actually go after these items. And, you know, that's where there's some of the issues actually come around as well, because from a political perspective, who is it in that country that can then go after those entities and recover them on behalf of the country? So, you know, there are lots of different issues in there as well.
Just to very quickly recommend a book by Pierre Losson, Losson, called The Return of Cultural Property to Latin America, which looks at precisely these claims that are not legal, but that happened before the relevant laws, including a claim from Colombia holding that a previous government had illegally gifted a collection to Spain, which should therefore be reclaimed. And Spain is like, haha, nice try.
Yeah, they've done that with Nazi art too recently.
Yeah, I was going to say, on a similar point, you're going to have lots of troubles with active state defenses, and timeliness for most of these claims is going to be a very high hurdle to clear. But for any of this kind of property, and this is what a lot of the early Nazi looted cases turned on as well, is there a point at which the chain of title is interrupted by some defective act, right? So if there is somebody in a government who sells an object that they didn't have the authority to sell, right? Hypothetically, if somebody in Kathmandu had sold something and pocketed the money that's inconsistent with the nature of the object or the way it's used or whatever under the laws of the place, then you can argue, okay, at that point, the lawful title is interrupted and everybody after that holds corrupt title, which at least here in the United States and certainly in New York, will not be cured by subsequent good faith acquisitions. It might not get you all the way there, or depending on your perspective, it might be sufficient to defend yourself on things like laches, which New York courts, both federal and state, have been very receptive to, that if there's a claim on an object that you could have known about, they're going to be pretty strict with how old the claim is. But certainly the validity of the title transfer is one important thing.
Well,
yes.
All right. I think we could keep on going, and we can certainly talk after the program, but I think otherwise they're going to pull us off the podium in a second. But thank you all. Thank you to the panelists.
Thanks, you too.
We are about to begin our next session. It is my pleasure to introduce our keynote speaker, Irina Tarsis, founder and managing director of the Center for Art Law.
Hello, greetings everybody. I think we're live. It would be great if somebody can wave to see that you can hear me. Perfect. All right, and you can see me as well?
Yes, we can see you.
Brilliant. All right, so before I begin, I am going to try an experiment. All right, you should be able to hear this, right?
I don't think we can hear the audio, but if you go to the options on your share screen.
All right, that's useful. Hold on, let's try it again. All right, it might be a little bit loud, all right? So let's try it again.
Похилилася чогось наша славна Україна зажурилася, а ми тую червону калину підіймемо, а ми нашу славну Україну розвеселимо. Ой, у лузі червона калина похилилася, чогось наша славна Україна зажурилася, а ми тую червону калину підіймемо, а ми нашу славну Україну розвеселимо.
All right. So I hope you were able to hear part of the song that has been remixed. It's an old Ukrainian folk song that was remastered by a contemporary artist of a group called Boombox, together with a South African performer artist, the Kipnis. And this song has been going around the world, energizing a lot of people. In this particular instance, Kipnis is actually making a little bit of a fundraiser, and he's able to donate money to the Ukrainian aid. And it's a very interesting way of experiencing Ukrainian culture. So I wanted to share this with you before we start with my presentation. All right, I hope you can see the slides now. And it would be very helpful, since I'm unfortunately not in the room with you, to get a little bit of feedback, at least maybe from those who are online. All right, can you see the slides? Should we try it again? All right, I don't really see what you guys are seeing, but
We can see your slides.
thank you so much. Thank you for the feedback. All right. I'd like to begin by saying thank you for including me in this very important and interesting conference. I was able to listen to the first two panels, and I am humbled to be addressing you today in the keynote format. The subject of my keynote is called, you can see, Ukraine on My Mind, Cultural Heritage and Armed Conflict. I have been thinking about the best way of presenting the subject to you, and I don't think there is one best way, so I will try to approach this topic from different angles. And I've been thinking about the theme of the conference, or the title of the conference, Duplicate, Decolonize, and Destroy. And I've been trying to undo the destroying and part, particularly in this instance. All right, so I am the founding director of the Center for Art Law, and I'm also an attorney and art historian, and I usually specialize in provenance research in subjects of copyright and fair use, authenticity. I have litigated in New York courts usually on behalf of artists whose property galleries forget to return. I've done provenance research for Nazi or looted art, and I wish I could be with you in the room in person, but I'm addressing you from Switzerland, so I thought I would bring you to where I am. This is a view of a square in Zurich, and you can see that there are a lot of flagpoles that are empty because we just had a big international film festival, so all the film festival flags have been taken down, but the Ukrainian flag, the Ukrainian national colors are still showing. And as you probably know, Switzerland is notoriously neutral. Well, I choose to think that in this instance, they're not neutral. They are at least showing that they're not neutral. They have been supporting Ukraine in the war between Russia and Ukraine since the war started. If you walk up from this square, it's called Sechs-Leute-Platz, you will be right near the Kunsthaus of Zurich. There's a new museum built, which opened last year, and there is art on display at the museum that has been causing a lot of controversy. This is the so-called Burley legacy. Emil Burley was not a military man. That's not what he is known for. He was a manufacturer of ammunition and weapons. He happened to be making weapons at the right time and in the right place. He sold quite a lot to the Nazi government. He sold some to the Soviet government, and he made a huge fortune. By the end of the war, by the end of 1945, his fortune was about 140 million Swiss francs. And part of that fortune he put forth or towards buying art. He had a good taste, and there was a lot of art to be bought, including paintings from the Jewish collections that were looted during World War II. So as he was selling guns and ammunition to the military, he was benefiting from the profits he made by buying art from people who were dispossessed of this art. The museum opened last year. There has been a lot of critique of the fact that Burley collection is on display. And not to mention that a lot of the paintings that he bought were looted, and he was sued for that. And he had to actually return a number of paintings to the original or the rightful owners, including Paul Rosenberg. So this is not a very nice legacy. And I would like to keep this in mind as we go through my presentation. So cultural heritage and armed conflict. What is culture? Who owns culture? We have definitions. We also have our ideas. Let me back up. So this is my first keynote. I have done presentations and lectures in other contexts. I teach, but I have a sneaky suspicion that the reason I'm addressing you in a keynote format is because due to no actions of my own, a long time ago, I happened to be born in Kiev, and I happened to be a native Russian speaker. And then I came to the United States when I was 12. I kept my interest in Russian culture and increasingly Ukrainian culture. My parents did make borscht, but it was not a particularly interesting thing. It's a beet soup. I know lots of families cook it. But we are faced with the question of what is culture, who owns it, and why and how do we determine that? So one of the ways we can think of culture is when somebody else tells us that what we're experiencing or seeing is important. So UNESCO has a World Heritage List. I'm sharing with you the map of Ukraine. There is an updated version of it with areas that are contested. But Ukraine is home to at least 7 UNESCO sites, and one of them is the Sofia Cathedral. So the theme of our presentation today is the bell tower of the Sofia Cathedral. Who else can tell us what cultural heritage is? We have lots of international norms and treaties and guidelines, and as Nick O'Donnell said, this is a legal conference, so we do need to talk about laws just a little bit. Wars have happened forever, and like epidemics or pandemics, we were due for one. I had thought that in the 21st century, we would be able to avoid something like that. But actually, I learned that at this time, there are at least 30 armed conflicts happening around the world, despite the fact that we have a lot of conventions and efforts not to have armed conflict. So the ones that might be most relevant to our conversation today are the 1954 Hague Convention on the Protection of Cultural Property in the Event of Armed Conflict, and 2003 Convention on the Safeguarding of the Intangible Cultural Heritage, right? We have the privilege of hindsight, and we could do better. So the 1954 Hague Convention followed inconveniently World War II. had we had this already on the books, maybe the losses would have been different, or if the losses were different, we might not have had the convention. In any case, as I was preparing for this presentation, I kept coming across Confucius' name and his saying that signs and symbols rule the world, not words nor laws. And unfortunately, I think some of that may still be the case. We are aspiring to using words instead of guns and having laws to predict our lives, but this is a Russian saying, "Durakam zakon не pisan," laws are not written for fools. And unfortunately, I think this is one of the observations that are still true. Law is not written for fools. If it is written, then it is not read. If it is read, it is not understood. If it is understood, then wrongly, because he is a fool. I would put to you that wouldn't it be nice if all the wars could be stopped before they started? I think that would be amazing. And if they couldn't be stopped, that we would be able to stop them within hours or days of their commencement. I think we should be able to figure out a way to do that. Not have wars, I'm an optimist. And if there are wars, maybe there are levers or points of pressure that can be applied to get the oxygen out of the war machine. So this is 1990s and 2000s. There is a Hague Convention from 1954 to guide us, but there were plenty of crimes of war against cultural heritage in the Balkans, libraries destroyed, museums affected. Looting of the Iraq Museum, we will be marking a 20-year anniversary next year. And really, for me, the world, and maybe for many people, has now been divided into before February 24th, 2022 and after. What I'm showing to you is my before world. I spend a lot of time doing Nazi or looted art research. One of the books that has been influential in my studies was Beautiful Loot by Konstantina Kinsha and Grigory Kozlov. And the last few times I traveled to Ukraine, one was for my aunt's funeral, and I am thankful she did not live to see this war. And the other one is in connection with a painting called Portrait of a Young Artist, Portrait of Magda Mendel, which is a family heirloom that is in a museum in Uzhgorod. The family resides in the United States but is trying to restitute the portrait, so far unsuccessfully. So before February 2022, my focus was on Nazi or looted art. There were headlines about Ukraine refusing to return looted paintings, about exhibitions of looted art in the Crimean Museum. There was this case, I think many of you are familiar with it, and I will very briefly mention the Ukrainian connection. It's an old master, Lucas Karnak's diptych of Adam and Eve. We go back way to the very beginning of at least the origin of the world. This work is thought to be done around 1520, and it was located in Ukraine in 1918, 1928. It was identified as a work by Karnak. It was actually, I believe it was in the Sophia or in Lavra, in one of the two places in Kiev where it appeared. We don't know exactly how it came to Kiev. Maybe it came by way of Poland, but it was one of the objects. I'm calling the two one objects, but they were deaccessioned, part of the nationalization efforts by the Soviets, auctioned in Berlin, purchased by a Jewish art collector, and on and on and on until the lawsuit for its restitution was decided ultimately in favor of the museum that currently has possession of the paintings. In 2020, Ukraine mentioned there was, a political or a PR stunt saying that we should revisit the Ukrainian claim for these works because they were ours before the revolution. Well, lots of things have happened since. In 2014, because of the uprising against the then current Ukrainian government for the decisions they were making vis-a-vis Europe or Moscow, there was a Maidan, one of Maidans that Ukrainians do from time to time when they're not pleased with their government. They kick one out and bring the other one in. a number of artworks were on loan from Ukraine, including museums in Crimea, to the Netherlands. I would like to bring to your attention that there were a number of objects on loan from the Russian Federation in Ukraine at the same time. And in 2014, Russian Federation quickly asked for their icons that were on loan to be returned. They were returned. The objects on loan to the Netherlands, however, got stuck because Ukraine was asking for them to be returned to Ukraine because that was the country that lent materials. And Crimean museums were asking to get these materials back. But by that time, we had annexation of Crimea. And so the question was, where should these artifacts go? To the best of my knowledge, they are still in the Netherlands. Also, what was an interesting disruption, I'm using the word interesting in quotations, there were a number of paintings found in the Simferopol Art Gallery that were actually from a museum in Aachen. They were part of the trophy art collected after World War II. They ended up in Crimea, and there were very active discussions before 2014 about return, or at least some kind of a fair and just solution where two museums would be able to share possession of the pieces. Well, after the annexation of Crimea, the whole discussion of restitution of these paintings to Aachen ceased to continue. There is a lot going on with Donbass. That's another area that was contested before 2022. But there were lots of efforts by such interesting entities as Museum Open for Renovation, where there were efforts to protect cultural patrimony, Soviet cultural patrimony, photographs, archives on the territories that were in armed conflict. I think you might have seen these announcement headlines that there were certain objects blown up. There was a sculpture that was destroyed in 2015, the territory of Donetsk. There was cleansing of perverted art. There were articles about Scythian gold that did belong to Ukraine and the Russian Federation. A very interesting headline in 2016, Russia may have Crimea, but it can't have this ancient Scythian gold back. The world did not start or end on February 24th, but when I woke up and I told my husband good morning, he said, it's not a good morning because his family is in Russia and my family is in the United States. We speak Russian to our kids, less so now. I'm not trying to cancel Russian culture, but I am very angry. And this disaster is not only personal to me, it's personal to millions of people. Millions of people have been displaced, millions of people have been dispossessed. Too many people have been killed. It's not a tenable or acceptable or a credible scenario. I promised to myself not to show you any really sensitive content, but this is sufficient. This is a theater that was in Mariupol. You can see that there are letters written on both sides, which says children. This building does not exist anymore, and we don't know how many people died because this place was actually bombed. So there are lots of questions. Historical questions, perpetual questions. Who is to be blamed? Кто виноват? And what is to be done? Что делать? I would like to make you think about who is asking the question and where do we begin? One of the places that you might want to begin, if you have the time, there is a wonderful Yale University lecture series that is happening right now, taught by Timothy Snyder. It's called The Making of Modern Ukraine. It's very accessible, it's brilliant, and it puts into a large world context the reason why the situation in Ukraine is not just a regional, small problem and really concerns all of us. Immediately after the Russian invasion of Ukraine, there were many statements made by international organizations, national organizations, art historians. There's an astounding number of reports and conferences and efforts underway There have been fundraisers and donations and concerts, and the amount of photographs produced and memes and efforts, it's astounding in a relatively short period of time. But I would put to you that it would have been so much better if this whole thing did not start at all. You know, for me as an observer, because I'm sitting in the comfort of my office, and I'm not sure how many of you have traveled to Ukraine in the last 8 months. For me, the fact that the International Council of Museums is putting together a red list for Ukraine is shocking. But maybe I shouldn't be shocked. Maybe every country, every type of cultural heritage should be listed on the red list. Or maybe that would be the worst case scenario. I feel like this is a post-COVID, it's like a long COVID problem. Every word, every statement can be either reversed or misconstrued or construed in a different way. So every country should have a red list, or no country should have a red list. I don't know, but ICOM is currently and still preparing an emergency list for Ukrainian heritage at risk. On March 2nd, I think this is pretty quick, and if you are not following this entire process, you would say, wow, that was a quick reaction on the part of the Attorney General, Merrick Garland. He announced a launch of a new task force called Collect to Capture Task Force, with the idea to hold corrupt Russian oligarchs responsible for this war. I wonder if Burley would be a person of interest, and in fact, he was a person of interest because he was selling weapons to the Germans. But what is this Collect to Capture Task Force? It's an attempt to locate assets that belong to persons on sanctioned persons lists. I believe that we are all interconnected, and not necessarily like mushrooms, but we can talk about anti-money laundering. We can talk about international law, and we can talk about humanitarian law. So there have been lists of sanctioned persons created before 2022. After 2014, after the annexation of Crimea, there were already a number of individuals placed on the sanctioned persons list, and this list keeps on growing. What does it mean if somebody's name is on a sanctioned persons list? Well, they can't buy or sell. They right now cannot import luxury goods into the Russian Federation. If they have bank accounts, the bank accounts need to be frozen. If they have art collections, they cannot be moved. Objects cannot be sold from these collections. So if you have any information related to corrupt Russian oligarchs' property, there is something you can definitely do to try and end this war sooner. There are a lot of efforts that non-lawyers and non-Ukrainians have created. One of these efforts is, I believe, it's an outstanding initiative by cultural heritage professionals, and maybe some of you have contributed to it. It's called Saving Ukrainian Cultural Heritage Online, SUHO, with the idea that, no, we're not going to travel to Ukraine right now, although we might want to go and clean the streets and plant new flowers and, you know, hug all the elderly and children and so on and so forth. But what we can do is we can try to archive materials that are available for the time being, because there have been instances where certain museums, their websites would go dark. You would not be able to find information. This is not new to the Ukrainians. It's not new to the Russian Federation. It has happened over the years that when you have something online, it can either be co-opted, taken down, and lost. So SUHO has been working very hard on archiving materials. Ukrainian government, Ministry of Culture, and others have been cataloging cultural heritage losses. And unfortunately, this list keeps on growing. There have been a lot of reports whether Ukrainian heritage is targeted or it's just incidental loss. I don't know. You may not know, but I know that if there was no invasion, if there were no invasion on February 24th, none of this would have happened, and this presentation would have been different entirely. So one of the destroyed artifacts on the list is these 9th to 13th century stelas. They're not entirely destroyed. Not all of them are destroyed. We don't know under what circumstances they're destroyed, but the fact that they have been touched and destroyed in any way, shape, or form should send shivers down everybody's spine. I'd like to notice that there are amazing number of scholars and journalists who have been working on the subject. Sophia Kishkovsky is one of them, and I'm, for one, very grateful for their work. One of the people who's been very active is Konstantina Kinsha. That's the co-author of the Beautiful Loot book. So he has been also focusing more on the Ukrainian cultural losses in the present time. UNESCO, as I mentioned, has been doing quite a lot. They are keeping track of the damages. They have this list that gets updated quite regularly. Right now, they have corroborated, checked that there are over 190 sites damaged. The Ukrainian list more. They list 300 or so sites damaged, but not fully destroyed. This is a photograph of the Ukrainian musician, one of my favorite musicians, who brought a number of his colleagues to Kharkiv to perform in the space that was demolished. I'll show you the space again momentarily. And there have been really great efforts by people who don't have much to do with Ukraine to try and help. There are charitable auctions, there are lists. For example, IFAR put together a list of useful resources, and they were one of the first to organize a conference on the subject of Ukrainian cultural heritage. This building was a library. This building will appear again in the remarks momentarily. The World Economic Forum historically has seen a lot of Russian business people, Russian oligarchs come and speak. This year, the Russian house was closed. It was converted into an exhibition with assistance of the Pinchuk Center. It was called the Russian War Crime House. And it documented a lot. Well, there was a map of places that had been affected and many, many photographs of journalists, some photographers who have been affected themselves during this time. The gentleman here, that's Timothy Snyder. He was one of the speakers at the World Economic Forum, and he has been a very vocal supporter of assisting Ukraine, because it's not just assisting Ukraine, it's assisting a wider cultural community. Remember the picture of the beet soup? I don't know how I feel about it. I feel like, well, I don't know how you feel about it, but on July 1st, UNESCO actually inscribed Ukrainian borscht cooking into the list of intangible cultural heritage in need of urgent safeguarding. It's a fact. It has been done. Is that the most important step? No, but it is sending a message that there are lots of different manifestations of culture, and we want to protect as much of it as possible. European Cultural Heritage Days just took place a couple of weeks ago, and European Parliament issued a very interesting, very detailed report of the efforts, both international and domestic, vis-a-vis protection of Ukrainian cultural heritage. I will be happy to share that with you if you wish, but this report can now be updated further. And lots of colleagues from museums have been traveling and figuring out where they can send supplies, where they can send digital materials, equipment, packing materials, how they can help their colleagues in Ukraine protect what they have assigned to them. So here's just one example. Heritage Emergency Response Initiative is an initiative that Ukrainian museum curators and I think just volunteers have put together. They have been working with institutions across on the other side of the border, westward, looking for assistance and guidance. They are, many people are taking 3D photographs. This is again the image of the destroyed library here. The idea is that at some point, some of these buildings will need to be rebuilt and the heritage is not going to be lost entirely. So there are many institutions, over 100 institutions that are receiving assistance again and again. This is a very quick disclaimer. Unfortunately, I have been sifting through information in very unlikely places. I have two Telegram accounts. I'm not proud to say that that is the case. I'm reading information that comes from bots and propagandists. And I learned, and I'd like to remind you, if you care, depending on how you spell your searches, you might get different information. If you spell, for example, Luhansk with an H, you get Ukrainian sources, and if you spell it with a G, you get Russian sources. And on the same day, same Google search will give you different information. So there is more than just military operations occurring. All right, so what can we do? I think that's where I would like to focus your attention. Our culture has been evolving. In the 21st century, I think we can very well do without using antiquated weapons that are not precise or at all. We have information that DAOs are raising money for Ukrainian army. There are many NFTs created, many artists are performing both for charitable concerts and creating posters and doing exhibitions. If there are artists in the room, you can do a lot. If there are museum individuals, museum professionals, we can do a lot. And lawyers, well, this is a camp that I organized this summer. And I learned that I should not be working with kids so closely. It's hard having so many children vying for your attention. But the camp was called Viel Spaß, a lot of fun. All these kids came as refugees to Switzerland, and they spent quite a lot of time apparently eating traditional and Swiss food, painting a lot of national colors, playing together, and trying to prepare for the next school year. It's not an initiative, it's not a revolution. There's a National Agency for Corruption Prevention. You may know that statistically or historically or according to objective sources, Ukraine was, and I don't know about now, but one of the most corrupt countries in Europe. And so donating money to Ukraine at this time feels both necessary, urgent, vital, and strange, because we don't know where the money is going to go, right? This entity is attempting, I think, I'm an optimist, I think they can do this. They're trying to fight corruption within Ukraine. They're also working on maintaining lists of the sanctioned individuals. They work with counterparts in all countries, United States, France, Germany, England, you name it, on trying to minimize the impact as much as possible of the Russian attacks, Russian funding of the war machine. So they have a list both of sanctioned individuals. If you happen to be working in an auction house or a gallery, you probably want to check whether you're dealing with a sanctioned person or not. They are keeping track of the losses. They're keeping track of not only crimes against cultural patrimony, but crimes against individuals. So imagine a museum in 70 years or so with art owned by Oleg Deripaska or the Rosenberg brothers or Vekselberg. These are faces, not all of them, but many, the names definitely of people who are listed on the sanctioned persons list. And they are known to have collected art for the last many, many years. Somebody knows where that art is. And that art could at some point surface. And at some point it could be given as a gift to a museum in St. Petersburg, Moscow, somewhere else. There could be a room named after Vekselberg. There could be a room named after Deripaska, or their property can be, if identified, and seized for lawful purposes. For example, if somebody is trying to avoid sanctions or somebody is engaged in money laundering. I think we can avoid a lot of embarrassment for our kids down the line, and not have the Burley legacy stamp hanging over. One of these images that I'm showing you, from sanctioned persons to seizure of cultural property, just this week, was it this week? I think this week, Supreme Court declined to lift sanctions against Deripaska. He's one of the very rich individuals who's supportive of the Russian government. He is also being indicted for trying to avoid sanctions. So there's a lot going on vis-a-vis this one particular individual. I believe his home was, I don't want to say raided, but property was taken from his residence in New York, including a painting by Diego Rivera. All right, so to avoid having a museum named after or with contaminated art from one of these individuals, it's possible to report assets. And here I'm thinking about artworks that are owned by oligarchs to the war and sanctions list. If you wish, you can report the same to the Collect to Capture Task Force. If you don't want to be identified with your reporting, you can let the Center for Art Law know, and we will report this on your behalf, or just we'll do provenance research ourselves, and we will convey this information onward. I keep mentioning Anton Chekhov here. I'm not interested in canceling any culture. I'm not interested in canceling Russian culture, but he is a credit that was saying that any idiot can face a crisis. I'm not sure that's true. It's the day-to-day living that wears us out. I believe that we are all worn out by military armed crises that seem to be coming one after another. So what can we do to stop it? I think we can get the oxygen out of the military machine by using economic sanctions, using economy instead of military. All right, so why are we doing this? Again, I understand that we are in a law school forum, but we are also, we have our moral compasses. So what we do is supposed to resonate. And when I fundraise for certain causes, they resonate with me. My daughter, for example, she told me quite early in March, I think, she said, I understand you feel very strongly about this subject, but I don't, because there's so many other causes and crises that resonate with me. So while she is looking to help with reproductive rights and women's rights, why are we doing this? We are doing it, I think, for the future. And here I'm happy to share with you plans for the future. This is a library that was demolished in Chernihiv. There are lots of architects thinking about how do we rebuild? What do we do? So some of the money that is being set aside or that will be used after property is seized from the sanctioned persons will be used for reconstruction. Maybe I'm an optimist, but I think that is going to be the case, at least for some. Here's another building. That's where Okean Elzy and other museums, musicians were performing. This center was bombed in Kharkiv, and here is a plan, one of possible plans for renovation. So the idea is not to demolish and forget, but the idea is to come back and rebuild. And this is the drama theater in Mariupol that is one of many tragedies of this war. May be rebuilt. So I would like to end my keynote with a call to action. I know there are lots and lots of causes, but I think checking to which causes you're giving your support, either time or money, is very important. Concerts, artists, families that need clothing for the winter, children that need musical instruments. Pick your cause and support it. Thank you. And if you have any questions, I'd be happy to answer them.
Thank you, Irina. We do have some time for questions if anyone in the audience has something they'd like to ask. Great. It looks like at this time, oh, wait, there is one question. Hold on. Stay tuned.
Yeah, good afternoon, Irina. Oh,
Hi, I can't hear you. Sorry.
yeah, good afternoon, Irina. I have a question. How many, you mentioned a lot of work and a lot of charity. How many Russian artists involved in also helping this to happen? Because we've seen obviously Ukrainian artists on the side, but that's their family, that's their land, that's their heritage. So it's obvious that I know for sure, and I know personally some Ukrainian artists who are involved. How many Russian artists joined in, helping those projects? Not how many, of course, not the number, but like, is it happening?
Yes, it is happening. There are many people who have been vocal about their positions. So one of the problems, and I believe, Ukraine, I'm an optimist. I think Ukraine is going to win. I don't know what the victory is because there has been so much loss of life. But I do believe Ukraine is going to win. I think there's a big tragedy with the Russian Federation because people have not been able to express themselves. They have not been able to really protest because they're very aggressively attacked and beaten and labeled as foreign agents. There are a number of musicians that have been speaking out against the war, a number of artists. There have been curators and theater directors quitting. But it is very dangerous to speak against what the Russian Federation is doing. With the partial mobilization last month, many people have fled the Russian Federation, but there are artists who are doing their best. And there are lots of individuals who are trying to help Ukrainians on the territory of the Russian Federation. It's not as easy to document. If you want, I can send you a long list of performers who have been listed as foreign agents, effectively indicating their position on this.
Yes, thank you. And yeah, that was I wanted to mention because I know in Russia, a lot of artists like Andrei Makarevich, Galkin, and the list goes on. Eventually, they've been announced as a foreign agent because that's the new thing in Russia. If you say anything against the war, you don't even need to support Ukraine. As long as you say I'm against this war, you become the foreign agent, yeah, иностранный агент. So yeah, how those people, were they able to do? They will only be able just to express, or were they able actually, to help and somehow getting involved, or it's still easier for only those who are outside of Russia at this point?
To the best of my knowledge, I feel like, in this instance, lawyers like to have the answers and they like to help and they want to, be certain. I can only be certain of the information that I can find. I know that many musicians are giving donations from their concerts to various causes supporting Ukrainian refugees and Ukrainian restoration efforts. We are going to find out more in time.
Thank you.
Thank you.
We have one more question.
Thanks. Hi, Irina, it's Nick. Can you hear me?
Yeah. Hi.
Thanks for the remarks. They're really moving. And obviously this creates the sort of awful conflict between the need to save lives and the threat to culture, which I won't ask you to adjudicate, but for those in the room with some experience and knowledge of cultural property law, if you had to say, what's the one thing or a short list of ways they can apply that knowledge and experience, where would you point them?
It's a great question. We haven't been called yet to assist, right? There is an opportunity, for example, for the art market participants. And here I'm thinking about galleries and auction houses and auction house experts and insurance companies and storage companies to share information. It's a decision that individuals can make. There is information about art collections that can be useful. As far as attorneys are concerned, a lot of work needs to be done right now with immigration. There are many people looking for asylum, not only Ukrainians, but also Russian citizens who are not supporting Putin's war. So immigration lawyers can do a lot. We can hire Ukrainian artists. The Center for Art Law was really fortunate to work with one of young Ukrainian artists on the poster we commissioned for our conference in July. We are working with a team from Ukraine to redesign our website. So these are sort of small projects that will have impact on individuals, individual artists, individual businesses. Larger goal, I think there probably will be a special court at some point to look at the crimes and to try and ascertain compensation. I think it's a vast subject, and I think the volunteers and the professionals who are making photographs and who are cataloging websites and who are doing all of that preparatory work, collecting evidence, there will be a need for lawyers to come in and use that evidence. One book for now, I think it's more of aspirational, that I would like to bring to your attention. It's called East-West Street by Philip Sands. Philip Sands is a French attorney who wrote about Lviv, and he wrote about the lawyers who created the terms crimes against humanity and genocide. They both actually went to school in Lviv. They were lawyers trained there before World War II. I don't think we need new legal tools. I think we have plenty of tools to address the problems that we're witnessing again and again. But we do need people who are willing to spend and sift through all the evidence and make cases, hopefully in the near future. And I'm strongly suggesting, asking, I know there has been a lot done for Ukraine already, and there are many other causes, but pick what makes sense to you and don't forget to support. I think to destroy is much easier than to create, but to do nothing could be even easier. So don't do nothing.
Thank you, Irina.
Thank you very much.
Everyone in the room could give Irina. She can't see us, but she can hear us clapping, hopefully. So at this time, we'll take a short break. 5 minutes. We'll convene at 1:48 for our final panel. We are about to begin our final panel, Erased: Protecting Cultural Heritage in Times of Armed Conflict. And the CLE code for this panel is EPC22. Again, that's EPC22. It is my pleasure to introduce our moderator, Leila Amindale, founding partner of Amindale and Associates and adjunct professor of law at Fordham.
Thank you. Good afternoon. It's an honor to be here this afternoon on the final panel of the day. Can you hear me? All right. Well, I wish we could end the symposium on a positive note, especially after the talk given by our keynote speaker. We have the task of discussing a topic that's very distressing. My esteemed panelists will discuss cultural heritage destruction and looting from the Nazi era to the current day. And I have the task of summarizing in just a couple of minutes the long history of heritage destruction and tools used to protect it. Lily, sorry, it's not going forward. Oh, thank you. Thank you. Unfortunately, the intentional destruction of heritage has been used as a tool to intimidate and control people with opposing viewpoints for millennia, despite prohibitions at national and international levels. It takes many forms. It can be the result of military strategy, ethnic or religious intimidation or cleansing, or retaliation. It can even be the result of negligence or failure to intervene. The protection of heritage harkens back to the early codifications of the laws of war, which distinguish art from other types of property, recognizing its unique status. A trial in ancient Rome serves as one of the first instances in which looting of heritage was prosecuted. Lawyer, orator, philosopher, and politician Cicero successfully laid charges of plunder against the governor of Sicily after he sacked towns for their artworks. Later debates in the 18th century on the nature of art, ownership, and warfare led to the use of this case as an ancient but compelling precedent in establishing the precursors to today's art law jurisprudence. Napoleon's plunder of art and antiquities in Europe and Egypt during the late 18th century and early 19th century was another turning point for legal scholars. After his defeat in 1815, nations sought to recover and return looted works to their original owners. However, the treaties of Paris signed in 1814 and 1815 did not include measures or protocols for the protection of heritage. Ultimately, the failure to arrive at a legally binding consensus for stolen art meant that colonial plundering became the norm rather than the exception. As a consequence, the earliest international legal instruments focused on the protection of heritage during armed conflict and belligerent occupation. However, these instruments focused specifically on the instances of armed conflict, which drew attention to the limitations of this framework and led to the enactment of additional protective mechanisms. However, these instruments were not honored. Due to the lack of adherence to these conventions, states banded together after World War II to draft and ratify a convention addressing the need to protect heritage during war. The 1954 Hague Convention and its two protocols served as a key source of legal obligations in this field at the international level. Sadly, though, it became apparent during the latter half of the 20th century that looting and destruction of heritage didn't only occur during war, but it was increasingly taking place outside the parameters of armed conflict, perhaps due to the demand for these objects by private collectors. So UNESCO was formed to tackle these issues through international cooperation and binding agreements. One agreement is the 1970 UNESCO Convention, which I believe the panelists will discuss, and that convention tackles the problem of illicit trafficking. The convention was later supplemented by the Convention on Stolen or Illegally Exported Cultural Objects, the 1995 UNIDROIT Convention, expanding its scope to private law restitution claims. Without further ado, I'm pleased to present our speakers, starting with Professor and Attorney Jennifer Creeder, followed by Attorney, Business Owner, and Heritage Advocate Elena Ambartsumian, and finally, Attorney Michael McCullough, partner at Pearlstein McCullough.
Hello, everyone. Thank you very much for being here. Thank you very much to the Fordham School of Law for the invitation, and especially thank you to Lily for reaching out, and Chris also for introducing me to wonderful people here, and for the kind introduction, Layla. Okay, so I will address in 10 minutes the scope of cultural heritage theft and looting during World War II. And focusing on this, I mean no disrespect to the crimes against humanity that occurred in loss of life, murder, but as has already been covered, when genocides occur, theft of property is also part and parcel of that, and cultural property has a special significance and has a special history. So I highlight this because when we talk about the theft during the Nazi era, it was different in terms of what happens in most wars, in that we have such an abundant record of what was stolen. It doesn't apply consistently to all things that were stolen, but we had inventories that were taken, we had auctions that occurred, and of course, people are still unearthing other evidence that's lost in archives, but this was open theft for the most part, and when we're talking about what the Nazis did. So there is a record of the official actions that occurred, but far more theft occurs that's not official. So after the war, many people have heard of the Monuments Men at this time, and the US position was that this art should be safeguarded, inventoried, and returned. And the original mission was to return it to the individual owners from whom it was stolen. And frankly, after the war, and we turned to the Marshall Plan, and we had concern about Russian tanks rolling to the Atlantic, the focus shifted to return the artwork to the source nations from where it was stolen. And frankly, from that point forward, we had a massive failure. So the source nations, frankly, did not do even close to enough to what they should have done to figure out who the works were stolen from and to actually return them. Oftentimes, you had the same government administrators who were in favor of stealing the art in charge of the government afterwards, and you had gross anti-Semitism that was rampant throughout the restitution process. So after the war, there were some institutions set up to help with restitution, but not specifically dealing with cultural heritage. And frankly, only the wealthiest of families who could afford attorneys on the continent had any chance of getting any kind of restitution. And when it came to specific things stolen out of individual homes and whatnot, when the Nazis forced Jews to make inventories of their actual properties. So to the extent that those can be pieced together, if something is a very famous work, there's a history of that sometimes can be found. But if something was perhaps a drawing on paper and a collection like that, the inventory doesn't specify that. So again, there's certain information that's available, more available than others, and other gaps. So military, criminal, and customs law all are consistent in terms of requiring the return of the art. And this has been the policy of the United States going back to before World War II. But the executive, the judicial branch, and the legislature were all in favor, and consistently so, of restitution. We seized quite a few objects that soldiers had brought back here as well. So the first case after the war was Menzel versus List, and the opinion comes out in 1966 after years of litigation. And since this case, sadly, the only success that survivors had in court came in 2014 with the famous Altman case that concerns the painting A Woman in Gold. And when that case came around in 2004, everyone was very optimistic. So by that time, we had some principles come into place that I'll mention in a moment. But since Altman, there's been very little success in our courts. So 1998, 1999, Portrait of Wally was seized. That's what launched the modern Nazi-era art restitution movement. So it was seized first at the state level, released, and then seized at the federal level. And the case went on for quite a long time. And this was one of those examples of someone who, she owned a gallery in Vienna, and she was able to hire a lawyer to help her try to get back certain things. But this she could never get back because it was held by the government. And the government's grounds for holding on to it, frankly, were a fraud, claiming that it was an honest purchase. They traded with someone who was a known Nazi profiteer and who was a known, he was obsessed with collecting Sheila objects, and frankly, regardless of the ethical situation that he was acquiring them in. So she was unable to get this back in her lifetime. After she passed away, her kids found an unsigned, undated note in her London apartment. Couldn't get anybody to listen to them until 1998 when this painting was on display in MoMA. Okay, so the Washington principles came about as a result of that seizure of Portrait of Wally. And to give the museums their due, the museums first came out through the AAMD and the AAM, but their own guidelines, and the Washington Principles mirror those. The Washington Principles were signed by a number of, I think it was 42 nations. And the basis of it was, okay, we haven't really paid adequate attention to what has happened with this Nazi looted art in quite some time. It's obvious that it's filtering out in the market. There's a lot more of it than we have really acknowledged and been honest about. So let's encourage people to come forward in order to assert these claims, knowing that the evidence might be mixed. And in light of that mixed evidence, let's come to just and fair solutions, recognizing that they may vary from case to case. And we were leading this in 1998. So the United States executive branch was leading this through the Department of State. And so people are looking at us as the model for what to do for restitution this many years later. This is the case that I mentioned that went up to the Supreme Court in 2004, solely on jurisdictional grounds that the Republic of Austria could be sued in the courts of the United States, after initially their courts demanded a $4 million filing fee just to assert the case. Two of the other paintings involved returned, wonderful, and she passed away not too long after they were returned to her, Maria Ullman. Since that time, there's only been one success in court, and it was this case, and it involved a relatively minor painting in terms of art history significance, in terms of value, and the person from whom the current possessor got it was a family member, and he was a member of the Nazi Party, and he directly stole it. So there was full record keeping and everything else. Since this is a law school, the claimant won on summary judgment. It was a slam dunk win. Nothing like that since. So here are some cases where the museums and then collectors decided to actually file first. So rather than encouraging people to come forward and to reach just and fair solutions and share all the information, they decided to sue survivors' heirs. And this, to me, crossed the line. And when this happened, it created a body of case law that is so against restitution that I don't know that we can really and truly come back to it in our courts. The Supreme Court just ruled on a case a couple of months ago that was favorable, but it's going to hinge on the application of California law, whether something's going to be restituted. At the federal level, after a series of these cases in the art market, right, we had this great divide. And so some people were saying the museums, have to make a decision about what's just and fair. Then there were people like me saying that needs to be left up to somebody who's objective. We signed 2 more agreements. One is the Terezin Declaration. There's a few other things as well, trying to strengthen the Washington Principles. In the end, frankly, it didn't really work. We passed national legislation called the HERE Act, which is in your CLE materials, and there's a gap in the HERE Act. The word latches was removed so that statute of limitations and technical defenses are what are controlling these cases rather than a decision on the merits of what is just and fair. So one of the lessons that I take from this is that the key to learn from these developments dealing with Nazi looted art for how to deal with not just this area of looting, but all of these others that we're going to face in the future, is to think about the transparency of information, which so much has advanced in that regard, that a lot more of that is possible. But we also have to concern ourselves with what importance will the passage of time have. And I think that different instances of war are different. So I don't think that there's a one-size-fits-all rule. Just to show you some of the other paintings, just to run through some photos for you to see examples of some of the objects at issue and some of these cases. That's all I wanted to show you with the rest of the slides. And if you'd like more information, I recommend you go there. One of my emails is there too, my professor email. And that's my cell. So I'm happy to take any questions after. Thank you.
Is it arrow or? Arrows, okay, great. Good afternoon. My name is Michael McCullough, and I'm here because I've been working in the art market for the last 24 years. When I was much younger than I am now, I started working for Sotheby's, an auction house here in New York. And I was one of the lawyers who worked with art experts in the company to determine two things. One was the artwork we were selling authentic, but more importantly for lawyers, was the artwork subject to a title claim. Because as you may know, auction houses give warranties to the buyer that both the artwork is authentic and that the buyer gets title, most importantly, gets title to the artwork. So when we talk about cultural property, there's always a question of whether the current possessor of the artwork or object has good title to it. So I'm going to discuss 3 objects that I've worked on over the last 24 years to give you a sense of how this works in practice. By the way, are we being recorded? We are being recorded, okay, great. I'll try to avoid the use of profanity, which unfortunately plagues cultural property discussions. So let's talk first about the Cambodian Civil War. Actually, I don't want to talk about the war. I want to talk about this object. So the Duryodhana was an object that stood at the base of a temple in Kokher in Cambodia. The Kokher complex is a complex of temples and sculptures in northern Cambodia. This sculpture stood with another. The base of the sculpture was in situ when this object was offered to Sotheby's in 2010 for sale. I had left the company in 2008, but actually this object was offered to the company earlier. I was familiar with this. In 2010, it was offered to Sotheby's and they imported it. At the time, I was a lawyer, I was working as a lawyer in private practice. One of my clients was the shipping company who imported this object. The shipping company got a subpoena, and when I saw the artwork and I saw the picture of it, I was wondering why exactly are they importing this? Because it's not importable. It must have been a mistake. Sotheby's never said exactly what happened. It had to be a mistake. They must have known that if they put this up for sale, the US government was going to seize it and forfeit it, which is exactly what happened. So what happened was the US Attorney's Office filed a forfeiture complaint against the object, and there was a court dispute about whether this object was owned by Cambodia or was owned by the current possessor. The issue in the case was whether the government's allegation that it was stolen in 1972 from the Kokher complex was probable cause for the forfeiture complaint. The answer the court gave was absolutely yes. And what Sotheby's said was, well, you actually don't know who stole this in 1972. That was the defense. The defense of the forfeiture was no one knew exactly when this left. The Cambodians thought it left in 1972. Now, after much more research during the forfeiture case, the government came up with more information to amend their complaint. But in essence, was it enough to allege, based on the Cambodian records, that this object was likely stolen in 1972? The court said, yes, that's enough to have probable cause to seize it and forfeit it. Once that was the case, under the forfeiture laws, the burden then shifts to the importer to prove it's not stolen. So there's a burden shift in our forfeiture laws. Once that happens, Sotheby's and the owner would have to prove that the object was legally owned, which is an impossibility. So therefore, they gave up. So they gave up the object. It went back to Cambodia. It's in a museum there now, and you can't see it in the picture, but the legs are broken off and the feet were in situ on a platform. The platform and the object have been put together again, and they're sitting in a...
Michael, can I interrupt for 1 second?
Yeah.
Did everyone see this object on the John Oliver show? Jen just said that to me. It was featured on the John Oliver show
John
this
Oliver
week.
did thing, yeah.
He did a whole segment on museums and he featured this.
It actually was
work
pretty
in
good.
the
I don't know if
MSP.
anyone saw that, but it was pretty spot on.
Yeah.
because someone was coaching him. I can guess who wrote that script for him, but.
His
yeah.
team may have contacted a number of lawyers in New York.
I guess, yeah, I can get that, not me. If you haven't got this yet, I work on the art market side, right? So I work for auction houses and people who own and sell these things. But this was absurd. They tried to import this. I don't know why they did. Okay, so here's another example. This is an archaic bull's head that originated in Lebanon. It was, at the time of its importation into the US, it was not known to have been stolen. It was purchased by a couple named the Beyerwalds, who live in Colorado. They were investors in a number of companies out west, and they created a big art collection, most of which included antiquities. This was one of the purchases they made from a dealer in London called Robin Symes, who was at the time the biggest antiquities dealer in the world. He no longer is. He's no longer in business. And he sold this sculpture for $1 million to the Beyerwalds, and they put it in their home. They had a big spread in House and Garden, in the photographs of their home. This was in the magazine. What happened after that is they got into financial trouble. Some of their companies weren't doing poorly. So as a result, they sold some of the things. This was one of the things they sold through Phoenix Ancient Art, which is here in New York City. They are now the biggest antiquities dealer in the world. And they sold it to Michael Steinhardt. Michael Steinhardt put it in the Metropolitan Museum of Art. No, I've got it opposite. I think I have it opposite. No, yeah, okay, that's right. Steinhardt puts it in the museum. Then Steinhardt finds out, based on some inquiries that of the museum and the Lebanese government making a complaint about the piece, that it could have been stolen during the Lebanese Civil War. Steinhardt then goes back to Phoenix and says, I'd like to return this. Phoenix contacts the Beyerwalds. The Beyerwalds say, sure, we'll give you your money back. So they actually refund his $1 million. It's still at the Metropolitan Museum at this time, but now the Beyerwalds own it again. So they kind of refund the money to Steinhardt. Little did we know, so we represented the Beyerwalds in this dispute. So Beyerwalds take it back. We go to the district attorney's office here in New York and say, okay, what's the problem here? They tell us we think it's stolen. We say, give us the proof it's stolen. Well, we don't have any proof it's stolen. We think it's stolen during the Civil War. We say, we don't care. So we filed a lawsuit against the Lebanese government and against the district attorney's office in order to clear title. What we found out in going through the initial discovery is that there is documentation that was stolen during the Civil War. Now, this is not a looted object, and there's a distinction that we can make between objects that are looted from the ground and those that are not. This one was actually excavated legally about 50, 60 years ago, and was actually in a museum inventory, a museum store. It wasn't actually on exhibition, and was stolen during the Civil War. So we found that information out. Our client decided to relinquish the piece, and it went back to Lebanon. So these are examples of how this comes up in the market. The trend you'll see here is that most of the objects that are sold on the market tend to come with a provenance. The problem is the provenance is either incomplete or false. As a market participant, it's very difficult to determine if the information given to you is correct or false. Why do people buy antiquities? Well, because they love them. Why do they buy really good antiquities that have a provenance that can't be proven? Because it's very hard to prove a provenance, very hard to document a provenance, and everyone wants the good stuff, right? That's, if you have a museum and you want good things, you have to go out on the market and buy them. So people participate in this market, but it's a very tough market to work in. Thank you for listening.
Hi, everyone. So I have the enormous and solemn responsibility of discussing what has been termed the worst cultural genocide of the 21st century, in 10 minutes, no less.
You may not have heard of the complete elimination of the Armenian people and their cultural heritage from the Armenian highlands, their ancestral home for over 7,000 years. Or you may be thinking that I am referring only to the Armenian genocide by Ottoman Turkey between 1915 and 1923, the carefully planned massacres of 1.5 million people that influenced Raphael Lemkin to coin the word and thus the crime of genocide. That's of course related, but instead I'm talking about what is happening today. And your lack of awareness may not be your fault, but rather as a consequence of SOCAR, the state oil company of Azerbaijan, which supports an oppressive regime domestically and a multi-billion-dollar money laundering operation that encourages politicians, academics, and policymakers abroad to stay silent, or worse, to spread misinformation. Azerbaijan, where I was born, ranks as not free by Freedom House, coming in at 9th place, tied with Libya, Myanmar, and Yemen, and it ranks 167th out of 180 countries on Reporters Without Borders Index. And in recent years, Azerbaijan has openly claimed that Armenians have no right to exist in the region. This is actually a map that Azerbaijan's President Ilham Aliyev is holding. He's ruled the country for decades after inheriting power from his father, standing next to Turkey's president and the director of BP in 2006, shortly after inaugurating the Baku-Tbilisi-Ceyhan oil pipeline. And interestingly, the map that they're holding shows Turkey and Azerbaijan's plans to connect their two countries through Armenian territory there in the south, which I'll get into. But first, to help orient ourselves so we even know what region we're talking about, another map. And another map. This is a map of the Armenian people's historic homeland, and in white you can see today's borders of the Republic of Armenia. These borders, even as recently as last month, have been shrinking due to attacks by Turkey's proxy state and also a Russian ally, Azerbaijan. This is the oldest surviving map of the world on the top left, called Imago Mundi, or the Babylonian map, which is on display at, guess where, the British Museum in London. And it dates back to 700 BC, though we understand from the cuneiform inscription at the top that it's a reproduction of an even earlier map that it references, but which has been lost. Armenia is the only civilization shown on this map that continues to exist today. Armenians are referenced here as the people of Urartu, which is what Babylonians called Armenians in their language Akkadian. Urartu is what we Armenians call Ararat. Armenians believe that Mount Ararat is where Noah's Ark came to rest after the Great Flood. This is the story in Genesis. And here you see a genealogical tree from the Torah showing Noah's Ark at the bottom, atop Mount Ararat, and the predecessors of the Armenian people through Noah's descendants. It's interesting that despite this history being recorded in the Bible, until recently, some modern historians were actually telling us that Armenian people had arrived from the Balkans. But with recent increases in genetic testing and research, it's been proven now that it's actually the other way around. A recent study of Armenian DNA revealed that modern Armenians show signs of mixture of local Bronze Age people. And moreover, these ancient populations since 1200 BC have not had any significant signs of admixture with any other population. So when researchers today want to study Neolithic Europeans, they study modern day Armenians, me. The Armenian people have maintained ethnic and cultural homogeneity for over 3,000 years, which is another way of saying that Armenians are indigenous to the Armenian highlands. And it is in these Neolithic to Bronze Age era discoveries in the Armenian highlands that we have found the earliest evidence of wine production, including the world's first winery from 6,000 years ago, and the world's oldest surviving leather shoe from around that same time. And of course, metallurgy. This is a Bronze Age model of the solar system found in Armenia. On the left and on the right is a Bronze Age chariot sculpture. By the way, they got the order of most of the planets right on the left, which is pretty good, but wasn't totally there. I could tell you about countless other artifacts and sites found in Armenia, from Karahunj, an astronomical observatory of stones that is 7,500 years old, and thus predates Stonehenge by more than 4,500 years, to what Armenians call Vishapkar, or dragon stones, often placed at water sources, many of which were transformed into cross stones when Armenia became the first nation in the early 300s to adopt Christianity. These cross stones are called hachkars, and if I had more time, I would speak about them. They dot Armenia's landscape, and in the last 2,000 years, the cross has become an important part of Armenian cultural and aesthetic culture. Spiritual and aesthetic culture. The cross also forms the cruciform plan of most of Armenia's churches. There are pointed cupolas evoking the peaks of Mount Ararat, some carved from the inside of mountains, and some which are, again, the oldest in the world, founded by Jesus' apostles or on sites where they were martyred or where their relics were housed. But instead, given the theme of this panel, I must address two other countries that intend to eliminate the Armenian people and their cultural heritage. And to do that, we're going to look at statements of Armenia's neighbors. If Turkey and Azerbaijan unite, they may wipe Armenia off the map of the world. Within the next 25 years, there will be no state of Armenia. These people have no right to live in the region. These are recent statements, not from the Armenian genocide 100 years ago. But on that topic, Turkey's President Erdogan, in a parade in Azerbaijan to celebrate their joint invasion of the Armenian Democratic Republic of Artsakh in late 2020, and consequent ethnic cleansing, stated, "May the soul of Anvar Pasha be blessed." Anvar Pasha is the architect of the Armenian genocide. And just a few months before launching that invasion, in July 2020, President Erdogan promised, quote, "We will continue to fulfill this mission, which our grandfathers had carried out for centuries in the Caucasus again." Of course, alluding to the Armenian genocide, which Turkey claims didn't happen. And in fact, Article 301 of the Turkish Penal Code dictates imprisonment for anyone who claims it did. I actually asked a Turkish friend to watch the video and translate because I couldn't believe that the president of Turkey was openly promising to complete the Armenian genocide. And she confirmed that the translation was accurate. There are many more statements like these by heads of state, from threatening to blow up a nuclear power plant in Armenia to claiming that Yerevan, the capital of Armenia, which is actually older than Rome, it's not a competition, but it's good context, is actually ancestral Azerbaijani Turkish land, to trying to issue a commemorative stamp that the Universal Postal Union refused to register because it shows someone in a hazmat suit fumigating the Armenian indigenous territory of Artsakh, which Azerbaijan calls Karabakh, as if the Armenians living there are a virus or a pest. Why is this the ideology of Azerbaijan? By the way, this is a park in Azerbaijan's capital, Baku, where children can practice torturing mannequins representing Armenian prisoners of war. One reason is because it's a state policy of Azerbaijan to pursue pan-Turkism, the formation of a single Turkish state, as one of those earlier quotes alluded to. The Azerbaijan Democratic Republic was created in 1918 as a proxy state in the Caucasus of the collapsing Ottoman Turkish Empire during the Armenian genocide. Before that, there was no such country or nation as Azerbaijan. The map that the Azerbaijani Democratic Republic submitted to the League of Nations for application as a new state, which of course encompassed wide swaths of Armenian territory, was rejected. Shortly after the Soviet Union formed, and then the Azerbaijani Soviet Socialistic Republic was created. It was the first Muslim-majority republic, and the Soviets were hoping that Turkey would also become communist, as Turkey was promising at the time. The Soviet Union relied heavily on the vast energy reserves in Azerbaijan. And in the process, Stalin carved up the recently created Armenian SSR and gave the Armenian majority populated areas of Nakhichevan and Karabakh Artsakh, among others, to the Azerbaijan SSR to placate Turkey. Azerbaijan's textbooks teach school children that Armenians are invaders, Armenians are the ones who massacred Azeri Turks, and Armenians were brought into the region by Russians and Persians only 200 years ago. Therefore, all Armenian ancient and medieval cultural heritage is fake and must be destroyed. In late 2020, Armenia filed an application with the International Court of Justice under the Third Convention, the Convention on the Elimination of All Forms of Racial Discrimination. And part of its request for provisional measures, which if you're thinking of American law, provisional measures are like an injunction, was an order from the court that Azerbaijan must stop destroying Armenian heritage in the territory that it occupies. The court granted this measure. Now, this is really important because an ICJ decision can be enforced by the Security Council, meaning cultural heritage can now be brought directly to the Security Council's attention. But a few weeks ago, Azerbaijan renewed its military assault on Armenia. You may have seen in the news House Speaker Pelosi with a congressional delegation traveled to Armenia 3 weekends ago to show her support. This is a Turkish member of parliament warning Armenia that the Turkish nation has the power to erase Armenia from history and geography on September 15th, 2020. Their goal is to connect the countries of Azerbaijan and Turkey through Armenia's southern mineral-rich province of Sunik, and I'm sure they hope to see another oil pipeline built in the future. So in the seconds I have left, I would like to show slides of several monasteries that have been destroyed by Azerbaijan in the last 20 years. Caucasus Heritage Watch, using satellite imagery, recently confirmed that since 1997, Azerbaijan has flattened 108 Armenian monasteries in the territory of Nakhichevan, as well as the destruction of what was the world's largest medieval cemetery, Julfa, involving over 10,000 intricately carved cross stones. Because after all, it's much easier to say that the Armenian people never existed in this region, once there is no cultural heritage as evidence to speak to. Thank you.
So I'm going to open up to questions, but I have just a couple of questions first. So first, Yelena, I'm going to start with you. And I have to say, thank you so much for presenting this and for educating the public about this issue so passionately. And it's something you've been working on for the past couple of years. And it's something we don't hear nearly enough about. So the first question I would have for you is, we're talking about legal instruments and what can be done. So what role does UNESCO play in the protection of these sites? Have there been, I guess, requests from international agencies, from the UN, from UNESCO to step in any way?
Oh, it's on, great. So the UNESCO conventions, as we know, apply during peacetime. And while Armenian cultural heritage has been attacked during arms of conflict and war, such as the deliberate shelling of Gazanjitsot's Cathedral in Shushi, where children were actually sheltering 2 years ago, the threat to Armenian cultural heritage is also great during supposed peacetime, as you could kind of see during the last slides. That area in Nakhichevan, which Stalin gave to Azerbaijan, is within Azerbaijan's territory and control. So they were destroying all of these monasteries and monuments during a time of supposed peace. But one of the problems with the UNESCO Convention or its application is that, and this is something I learned as a practitioner, as a student, I had an idea that all of these intergovernmental regimes operate on the principle of the rule of law, human rights, doing the right thing generally. And instead, as I learned, they're actually organized around the principle of sovereign equality of states. So when it comes to Azerbaijan and Armenia, when a lot of Armenian cultural heritage is within the borders of Azerbaijan, Armenia is kind of out of luck. Same with the Republic of Artsakh, which is an unrecognized republic. So interestingly, I have some examples of this, but in late 2020, UNESCO's Second Protocol Committee voted and decided to send an independent fact-finding mission to Nagorno-Karabakh, to Artsakh, simply to look at the status of the cultural sites. And because Azerbaijan has objected to that fact-finding mission, UNESCO hasn't been able to do anything. Meanwhile, Azerbaijan has invited the regional UN coordinator to Artsakh, to Shushi, to commemorate the 30th anniversary of Azerbaijan's membership in the United Nations. And so you have the UN flag flying next to the flag of Azerbaijan, meters away from a cathedral that's been partially destroyed that UNESCO can't get to. So that's one of the problems with UNESCO and UNESCO's application, that Azerbaijan can simply say, no, we don't want you to come, and UNESCO can't do anything. And sadly, I think a lot of these totalitarian states are now exposing the hypocrisy of the world's organizations and their lack of effectiveness.
So something that you said, I think would be kind of a nice segue to discussions about Nazi looted art, and the fact that when you have a government itself or like a ruling party doing these acts to its own citizens, it make me think of Nick O'Donnell, who's sitting right up here, who worked on the Guelph treasure case, which I think was like the last slide that you had presented. So I wish we actually had more time to talk about sovereign immunity and acts taken by nations against, their own citizens or people living within their borders. And I wish we had more time for that, but we don't. And I see we're really short on time. So I just wanted to ask you a couple of things about what you had discussed, and if you would like to address that in some way, and how that application, that treatment by the Nazis to their own citizens and people within their borders, how that applies in the case law. I welcome you to do that. But my question to you is, how do you think that the efforts in restitution from objects stolen during World War II might inform other restitution efforts, whether it involves cases that Michael was talking about, or perhaps, future cases that would involve Armenia or Ukraine and other nations that we spoke about today?
Sure. I should probably also mention that in terms of my work, I'm not only on one side of the issue in terms of only representing claimants. I've done work for museums to help reach compromises. I've worked on arbitrations that haven't gone to court, that have been successful. I also represent people in the art market, so buyers, collectors, sellers, and artists. So I think that the art market itself needs to play a very significant role in the success of future restitution efforts. Christie's and Sotheby's, I think, are instrumental in order to be a bridge between both sides in many, many circumstances. So what do we learn from the Nazi restitution effort? Well, first of all, information and transparency is essential. I can see use of blockchain for objects that are legitimately on the market and known, so we're not talking about looting out of the ground of unknown objects. I think that burdens of proof are incredibly important. So civil forfeiture does have potential to be abused, but which side has the burden of proof in a given case oftentimes dictates the outcome. The choice of law decision of which law to apply oftentimes dictates the outcome. And the problem with that is when somebody gets one of these cases, that's a crapshoot. You can never actually know on the front end what law is going to control. And that has been quite a problem when it comes to foreign statutes of prescription. And I've already mentioned that in the United States, at a certain point, everything's about the passage of time, be it statute of limitations or latches. And in other civil nations, after a certain amount of time, title usually vests. So whether it's 30 or 40 years. And then on the foreign sovereign immunities front, under international law, it was really impossible for someone who was a German citizen to sue the German state because the international law didn't apply to what the state did to its own citizens. And I think that the Foreign Sovereign Immunities Act has been used as a sword instead of the shield that it's intended to be in order to assert claims against survivors in order to block their ability to claim title. So some of the things that certain nations have done, I think of the Kingdom of Spain, I'm sure, Nick, you're thinking of the Republic of Germany. There's examples of people doing the right thing and restituting things. And frankly, when the dollar value and the cultural significance and whether something's a beloved painting or object or collection, when one of those is at stake, the current possessor tends to dig in its heels. And we need to bring the art market participants more into the restitution process. And frankly, they're afraid. They're oftentimes afraid of transparency because they don't want their things being seized. But I think when you see, we're talking about Michael Steinhardt before, I think when you see what's happened to certain collections like that, if you don't deal with these issues on the front end and get good advice about the provenance and not being willingly blind to bad provenance documents, things that just aren't credible. And you've seen too much of that. But I think that there's a very big shift in the antiquities market now where people are afraid to buy unless they can really verify that something was in the country before UNESCO, 1970. But that doesn't preclude the government from saying it was stolen before UNESCO and actually still seizing things. So the UNESCO 1970 line is a very significant event, but it's not the end all be all. And I know that there are people in the audience who are wondering, well, how far back do you go? And I think that it's different depending on what happened in different places. That incredibly moving presentation you just made, there's an argument under international law that there is no statute of limitations on genocide or cultural heritage destruction and theft. I can't see that ever really being adhered to by a US court because the doctrinal actions will bar it. But we can't make unrealistic expectations, especially when people can't even find their families or are in desperate situations to come forward within, X amount of time in every single situation. And, the claims will be done and the market moves on and forgets about everything. The Nazi era art restitution movement shows that there will be a reckoning. And now you're seeing it in the antiquities market as well.
So you mentioned the market, and Michael, you spoke about the market and your role in the market. What do you do to protect collectors against these forged, you mentioned falsified, forged provenance? Have you been seeing this more often? What do you do with your clients in trying to protect them against purchases that eventually, objects that are seized or forfeited, or very high profile clients? Like you talked about really high profile cases that you were involved in, and I don't think any collectors want to have their names in those headlines. So what do you do to protect them? What are some of the steps that you've been seeing, especially, or that you've been taking, especially with more and more forfeitures taking place, more and more seizures by the government?
Yeah, so I'll give a quick answer because I know some people come to these things to speak as much as to listen, so you might have questions yourself. But many of my clients have become more careful in how they buy things simply because there's, as Jennifer mentioned, there's more attention paid to the market and there's more attention paid to provenance and documentation. When I first started working in the market in 1998, the idea that you had to have a provenance to buy an antiquity was it was an odd thing to say, because provenance was just collected if it raised the value of the artwork, right? The provenance was just simply to prove it was an authentic artwork and it was owned by somebody. If the provenance didn't add to the value, it wasn't even printed in the catalog. In fact, as late as the 1980s, both the auction houses in New York used to print Nazi looting in their catalogs as provenance. It was actually part of the history of the object. So it was just provenance was not what it is today. What can you do? You need to be as diligent as you can. The problem is it's very difficult to authenticate historical documents. So in the case of the Gilgamesh tablet, there was an auction record for the auction of the object. It was supposed to be in a group lot, so there was not a photo. So it was a group of objects in a box, and it was supposed to have been in that box. It was impossible for us to verify whether it was in the box, but we had an affidavit from the buyer in the auction saying that he bought it. Now, he was a liar. But again, what can you do? You can only do as much as you can to prove historical information. The alternative is just don't buy anything if you can't prove it, that means there's no market left essentially, which, maybe that's the way it goes.
Well, to spark a little discussion, I was going to say, you used an interesting term, willful ignorance or turning a blind eye. I forget which one you just mentioned. So I mean, what would, how would
Yeah,
you respond to that?
well, look, I don't want
Get
to.
a little action on
I don't want.
the.
Look, you could name names, but there are people who have collected cultural property and have not cared at all about where it came from. Right? There are people who do that. There are other people who have been tried to be careful. There are other people who sort of just don't know enough. They've gone out and bought things without knowing. The Byrewolts are a good example. They were just sort of industrialists in the Midwest, well, not in the Midwest, in the West, the United States. They made some money. They went to a London antiquities deal and bought some things. They had no idea what they were buying and why they were buying. Now, they bought in the 90s when these issues weren't prevalent. There are these wonderful conferences you can go to and talk about cultural property. But, times change. So I think it has gotten a lot better. I mean, in my 24 years in working in this market, it's a totally different market than it was when I first started.
Well, I think that we need an objective place, a clearinghouse for the historical documents. And I set up a nonprofit because I think what is important in the antiquities market is, I don't think the market's going away. So I think you need to have cooperation from the biggest art dealers. I mean, and I think that we need to publicize what real documents look like to the people who are legitimate buyers in the market, not so that forgers can then, benefit and make better forged documents. But, and just like I criticized those museums that didn't allow courts to evaluate claims by resting on the statute of limitations, technical defenses, which, like the Terezin Declaration after the Washington Principles said, that's not the way these things are supposed to be decided. I mean, there's absolutely no trust when there's no objective third party. And not everybody's going to trust even a governmental third party. But, there needs to be a place where people can go that, both sides can trust that, what these documents that are being evaluated objectively, truthfully, and trying to weed out stolen things from the market so that they go back to the places they need to go back to.
Are there any questions from the audience? Yes.
I'd like to pursue this matter of protecting the purchaser. I'm in contact with a lawyer in Turkey. I knew her when she worked in New York. Her family were Armenians that converted to Islam to survive the genocide. But during the US invasion of Iraq in 2003, antiquities and art objects flooded into Turkey. Now, the question she raised is, if you buy something like that, like people during the Viking raids bought stolen books in order to preserve them, if you then have to turn it back over to somebody in Iraq, how much are you entitled to quantum merit? What you paid for it, your other expenses, your legal expenses, maybe another 10% for taking the risk or taking the trouble. I'm not saying that's the rule now, but wouldn't that be a good approach, she's asking?
Does anyone want to?
Yeah, I mean, look, it's an approach, but the idea of the claimant having to pay to get their stolen property back is something that many people wouldn't agree to.
Right, but they're paying for a service that somebody did to preserve that property, which can then be returned to them.
Yeah. Look, there's some precedent for the idea in the U.S. implementation of UNESCO, right? So under UNESCO, if there's a claim under the stolen property rule in UNESCO, the U.S. party can get compensation. It's almost never invoked, and it's almost never paid. But again, I think the problem is if you've had your property stolen from you, the idea of paying someone in the United States who's wealthy a fee since they held your stolen property for so long, I think most claimants would disagree with the idea.
Well, if your car was stolen and taken to another state, you would pay the guy who transported it back.
There is some precedent for what you're suggesting. So under civil law, basically using a concept of a bailment, when somebody has preserved the object for a long time and paid for it, then that payment price can be reimbursed. In my experience, that's not what the people holding the property today want. They want current market value. that's why they fight tooth and nail oftentimes if they're not willing to come and reach a just and fair solution. So there is some precedent for what you're saying, but I also think usually the rescue myth is a myth. The idea that people are acting out of the goodness of their heart to buy all this stuff usually is not true. And if somebody bought it for the purpose of preserving it for the Armenian people, they're usually very happy to give it to the Armenian people.
Jen, I think Jen made a great point with the part of the rescue myth. Also, you're talking about a country like Iraq giving payment, and you'd have to look at Iraq's patrimony law as well to see if there's anything under their laws that would compensate someone who saved the objects. And I've looked at the law before, and I don't know if anyone else in the room is more familiar with it, but I don't remember anything in the law allowing for that type of payment. I don't think most countries want to make those payments.
Civil law, you see some of that in civil claims, that if somebody bought it not knowing it was stolen, then their purchase price can be reimbursed.
I have a quick anecdote.
You also have to look at the context. You also, sorry, I was just going to say, we can turn this into a really big discussion. We have to look at the context of the war, and that the fact there was a conflict. Who could purchase something in good faith, with the whole world knowing that that conflict was taking place after 2003?
I have a quick anecdote about Iraq and restitution. So the Cornell University had a claim from Iraq for some cuneiform objects that were in the museum. And they decided, the collector who had put them on view at Cornell Museum decided to give them back to Iraq. This was prior to Hobby Lobby's case that I worked on, so I know sort of about the restitution. The objects were sent to Iraq. They went to al-Maliki, who was the prime minister at the time, and they've never been seen again. So they're gone. He took them. Who knows what he did with them? But they never went back. They actually physically went back to Iraq, but the Iraqis don't own them.
What I would really like to ask for your input on what you think should be done in the future to protect things.
I think as I'm listening to all of this, one of the things that has occurred to me, both as being someone who survived ethnic cleansing in Baku and now having many loved ones who were displaced from their homes in Artsakh 2 years ago, is most people under these circumstances, and I think you mentioned this, aren't even thinking about trying to get their property back. Many people who are leaving their homes didn't have time to, take documents. And so you're often not really thinking about, like, to the extent you do have objects, my family had paintings, you're really not thinking about that when you're just trying to get out of, the country or out of the situation safely. So I agree with a lot of what you said with respect to the doctrine of latches. And oftentimes it might not be the surviving generation, but their children, their grandchildren who are lucky enough to be able to afford therapy, who can then go back and deal with these issues.
Do we have time for one more question?
I have a question to Elena and the panel in general. My question is not about collectors' rights, but about what can be done when there is destruction of heritage, culture, by a government. And I'm talking about a particular case related to Elena's presentation. She mentioned the region Nakhichevan, which is, as Artsakh was taken away by the Bolsheviks and Turkey, and annexed to the newly created Republic of Azerbaijan. So it's to this day a legal territory of Armenia, but it's being occupied by Azerbaijan. And some years ago, in an effort to erase traces of Armenian history on this land, millennia-old cemetery of Hajj cars with Hajj cars and cross stones. She showed actually some of them in her presentation, and cross stones are oftentimes used as gravestones, and they are an essential part of Armenian cultural and heritage. And they were like gorgeous cross stones, a big cemetery, destroyed totally. There are satellite images of that being destroyed intentionally by Azeris on that land to be able to claim that they are actually the first inhabitants of that land. And this what adds to this insult is that there was at that time the ambassador to Azerbaijan was Matthew Bryza, and he didn't utter a word about this. So hopefully, let's say these lands are liberated, or even before that, is there anything, any way to bring the government of Azerbaijan, make them liable for this? Because this is crime, I guess. I'm not a lawyer, so I'm just curious. Is there anything done about this, and what can be done if not?
Thank you for your
Thank you.
question. So the cemetery you mentioned in Julfa was actually up to be inscribed on the World Heritage List. And in 2019, the list was published and the Julfa Cemetery had to be disqualified because it was destroyed. And, you know, sadly enough, the host of that UNESCO World Heritage session was Azerbaijan. So you can kind of understand the position that Armenians feel themselves in, where we see this happening, we see this destruction, Azerbaijan doesn't hide it, and then there's no punishment. You know, they do this all with impunity and openly. But I think that's one of the reasons why the Republic of Armenia chose to proceed through the CERD Convention, the Convention on the Elimination of All Forms of Racial Discrimination, because I think, well, sadly, the ICJ takes a very long time, like the briefing even isn't going to be fully submitted for another 2 years. But that's one way that the Republic of Armenia can seek to hold Azerbaijan accountable for cultural heritage sites, objects, monuments that are, you know, that Azerbaijan says are within its borders, but are Armenian heritage. And I know that doesn't, just to say something very quickly, when we talk about these Khachkars, every single one of these cross stones is extremely unique. And I think a lot of people might have, you know, their closest relationship with Christianity in this room might be from like Protestantism or evangelicalism. For Armenians, we've died over and over and over again for our Christian faith. The cross is such an important spiritual symbol to us. It represents Jesus's salvation. The vertical line is, you know, how we reach God. The horizontal line is that God became man for us. And so these are more than just like funeral monuments. They dot the landscape in Armenia. You can find them in random, very, very hard to reach mountaintops and see that there's melted wax there because people still come there to worship. We worship in churches, we worship outside, and these Khachkars, which are carved from stone, are such an important part of our culture. And so it's more than just, you know, someone destroying a gravestone. For us, it's like really hurting, you know, the core of our identity and of our culture.
So as promised, we ended with a very depressing panel. So
cultural heritage presentations have beautiful photos and depressing facts, right?
All right, thank you, everyone. Let's thank our panelists one last time. So thank you to all of our panelists today. Thank you for everyone in the audience here and on Zoom for attending our first in-person panel, or symposium rather, in a few years. I think it went well. And I'd like to invite all of you to attend the reception right now. It ended up being a beautiful day. And so feel free to grab a drink, take it out on the terrace, mingle, and yes, thank you all once again.